Test.
A very good morning, distinguished guests, colleagues, fellow citizens, and the general public. You're very most welcome to the 10th edition of the Radical New Bar Hybrid Press and Public Engagement, coming to you live from the Uganda Law Society House. I am by the name Robert Benon Jurua, a rule of law and litigation officer. It is my humble opportunity to say hello to you and welcome you once again to this engagement. They say justice must not only be done, but must be seen to be done. And it is at this very juncture that we wonder when justice is delayed, denied, or sometimes quietly negotiated behind closed doors, and especially wondering what happens in the courtrooms where we expect it to be a sanctuary of fairness that becomes a battleground for power in which we all keep wondering. Today, we are not gathering simply as observers, but very, very critically members to discuss a very important national topic. You are very welcome once again to this session, and we want to take the honor to have the privilege to have everybody here together so as we can delve into these matters. We'd like also to send special regards to those that are joining us online, as this is a hybrid session. We're very grateful for the members and all those else that have given us time to listen in. Today we would like to begin the schedule with, as has always been the case, the national anthems. We shall get straight away into listening into welcome remarks from the Chief Executive Officer of the Uganda Law Society, who has delegated that role to the Head of Professional Development and Members Affairs, who is in the building, who will read them unto us. And thereafter, we shall delve into session one of the issues that we're going to be discussing, which is something very critical to do with the aspect of fair hearing. And thereafter, we shall be delving into session number two, which will, of course, as well be a very intriguing topic that, of course, we are going to be listening into. And thereafter, we shall be having a moment of question and answer, after which we shall close the day and hope we shall have a very meaningful engagement to the benefit of the members of the society as well as the general public in our mandate of the Uganda Law Society Section 3 and C and D, in which we are here to ensure access to justice, democracy, and good governance. I would like to request all of us to rise on our feet so as the national anthems can be sung. Thank you. Thank you very much. You could kindly take your seats. Today I got a conviction to lead in the opening prayer. I want to believe I am also in the right place. Would we please humble ourselves for a prayer? Heavenly Father, in the name of Jesus, we'd like to thank you for today. We'd like to thank you for this gift of life you've given us on today. Bless your name, Father, for thus far that we have come. We'd like to thank you for this gathering, King of Glory. We'd like to place each and every individual that is here present and those that are online into your hands, King of Glory. For Lord, you are a God of second chance. You're a loving God. And Father, you are the Alpha and Omega, King of Glory. We'd like to ask that you forgive us the sins that we have committed and those that have committed against each other. And may you give us a clean slate to always start and be better every other day, King of Glory. As we get into this engagement, Heavenly Father, we'd like to ask for your wisdom, ask for your knowledge and understanding that whatever is going to be shared here and deliberated upon, King of Glory, shall be to the use of the members and also for the country at large, King of Glory. We pray for the speakers and pray that you use them as stewards to disseminate information that will be necessary to make a difference in this country and in the world at large. We pray this, believing and trusting in Christ Jesus our Lord. Thank you so much. We'd like to take the opportunity to welcome Miss Doreen Atukunda, who is coming in the stead of the Chief Executive Officer to read unto us the CEO's welcome remarks. Thank you.
Thank you so much, Jura. A good morning to all of us. Our distinguished guests today, Mr. Philip Karugaba, Mr. Stephen Karadi, Mr. Ronald Katshabe, Mr. Dean Luvowa Sava, Mr. Elotu Jonathan, Ms. Shamim Nambasa, the Governing Council of the Uganda Law Society, led by the President Isaac Semakade, our colleagues, members of the Uganda Law Society joining us physically and online, members of the press, good morning once again. I welcome you to this week's Rnblive weekly press and public engagement, a platform grounded in constitutionalism and in the defense of justice for all persons regardless of state, belief, or political inclination. This week, we turn our attention to two deeply consequential issues that strike at the heart of the constitutional governance and the rule of law in Uganda. These are not abstract legal debates. They are lived realities affecting citizens, families, and the illegitimacy of our justice system. Our first topic addresses the right to fair hearing and constitutional role of lawyers and the courts. The right to a fair hearing is not a privilege granted at the discretion of the state. It's a constitutional guarantee. Under Article 44 of the Constitution of the Republic of Uganda, the right to a fair hearing is expressly designated as a non-derogable right. This means it is absolute. It cannot be suspended, negotiated away, or diluted, even in times of emergency, political tension, or public pressure. We are honored to have our distinguished legal practitioners whose work has shaped jurisprudence in the areas of defense, constitutional order. Our second topic, political prisoners as the site of struggle for the Uganda GenZ movement, is deeply concerning. The discussion around political prisoners has been here for a long time, and many innocent people are suffering behind bars simply because of political differences. At the same time, we are witnessing a remarkable shift where young people, particularly the Gen Z, are stepping forward to stand up for human rights and the rule of law. They are speaking out, documenting abuses, and demanding accountability. This shows a generation that refuses to remain silent in the face of injustice. As we start off today's engagement, I urge all participants, including our legal experts, civil society, representatives and members of media, students, and all citizens watching us online, to keep in mind that these issues affecting the nation also affect us individually. Each one of us must recommit ourselves to the constitutional values that bind us together as a nation. This Rnblive platform exists to interrogate facts, and to ensure that justice and constitutionalism are upheld. With those few remarks, I thank you for your presence and participation and wish you a fruitful discussion. Thank you so much. Those were remarks on behalf of the CEO.
Thank you so much, Ms. Doreen Atkunda, for delivering those remarks on behalf of the CEO. Madam CEO, thank you so much. We know you're always following us online. We thank you for your blessing. Amidst your busy schedule, we really appreciate that you're able to speak to us every other Thursday in the same regard. So we ask that God bless you in your engagements so as we can have meaningful discussions. The topic that has been shared as topic number 1 is a very critical one, and it is one that asks for so much of deep thinking and interrogation, and it's something that has never gone away from the streets of democracy, fairness, good governance, equity, and all that has to do with rule of law. And we are going to use this opportunity to speak into various situations. And of course, we are also aware that there has been jurisprudence that has been prepared and organized and decided upon over time that helps us, the public of now, by those that were here before us and those that bothered and cared about this country way back, to make sure that our rule of law is always recognized. The right to a fair hearing, this is a preamble so as we can prepare our minds into the next speaker who is coming to be with us very shortly. The right to a fair hearing stands, of course, at the heart of Uganda's constitutional democracy and remains one of the most jealously guarded protections under the Constitution of 1995. Article 28 of the Constitution established that every person charged with a criminal offense is entitled to a fair, speedy, and public hearing before an independent and impartial tribunal. This right is therefore reinforced by Article 44C, as Madam CEO earlier on said in her remarks, which of course elevates it to a status of a non-derogable right, one that can't be suspended even in times of national emergency. Now, Ugandan jurisprudence has shown the gravity on the guarantee. In the landmark decision of Uganda Law Society and another versus Attorney General 2002, the Constitutional Court examined the legality of a trial that was conducted, concluded, and executed within a very short period of time. The court held that a process that denies an accused person adequate time to prepare a defense, legal representation, the opportunity to examine witnesses cannot meet the constitutional threshold of fairness. The court emphasized that the right to a fair hearing is not satisfied by speed alone. It must be accompanied by and procedural safeguards the accused from arbitrary injustice. As officers of court, we as lawyers play a major role in regarding the right to a fair hearing. Through legal counsel, accused persons are able to understand charges, challenge evidence, cross-examine witnesses, and assert their constitutional protection. This discussion, therefore, comes at a critical time, especially in regard to judicial innovations such as mobile court sessions and expedited justice mechanisms. While these initiatives are introduced to improve access to justice and reduce case backlog, they must always be measured against constitutional safeguards. Today, we have been blessed with the presence of one of the advocates that actively participated in that case in 2002, and would like that case is juxtaposed with what we are experiencing today. With us online, just a second or so coming from now, we are going to be receiving an advocate who is a partner with ENS Advocates. He is an advocate of rule of law, good governance, and human rights. Ladies and gentlemen, please welcome with me Mr. Philip Karugaba.
Thank you very much. Thank you very much, Rnblive. Thank you very much, Mr. Durrell, for that excellent introduction. Am I audible?
Yes, senior advocate, you're audible. Thank you.
Good morning, honorable members. My apologies for not being with you physically. I am profoundly honored and exceedingly humbled, as the late Shaka Sani used to say, to be able to address you today on this topic. But first, I would like to start by asking that we pay a small tribute to the dear departed in this case, starting with Reverend Father Declan O'Toole, his two unnamed companions who died with him and were unnamed in the proceedings. Sadly, to Corporal James Omedio and Private Abdallah Mohammed, not as a comment on their guilt or innocence, but in recognition of a shared humanity. Then to Honorable Justice Amos Finomjuni, who roared mightily and laid a good foundation to build on the constitutional provision of a right to a fair trial. May their souls rest in eternal peace.
Amen.
I'd also like to take a moment, thank you. I'd also like to take a moment to credit the intellectuals, the public intellectuals, the academics who took their time to write on this matter and whose work was the foundation piece for this litigation. That's Dr. Henry Ono and wait. So let me say a bit about this case. It is such a long time ago. It was interesting to look back at it and see how poorly I performed. But my only comfort is that if you look back 20 years and you can't see any way you could have done better, then you haven't grown. So my comfort is that although I didn't do so well, I have since grown and I can recognize many of the errors that I made at the time. So we handled this case with now Honorable Justice John Oscar Kihika, with Ladislaus Rakafuzi, never mind the spelling of his name in the judgment. And yes, the Jackson Karugaba named in as a party is no relation, is a relation to Mr. Ladislaus Rakafuzi and to our Deputy Attorney General. I'm speaking on the petitioner's side. So a summary of the facts with that 21 March, 2 soldiers are arrested for the murder of Reverend Father Declan O'Toole and his 2 companions in Contido district. On 25th March, 12:50 p.m., the 2 soldiers were indicted by a field court martial presided over by Colonel Sula Semakula and 8 other soldiers. 3 hours later, the soldiers had been tried, convicted, sentenced to death, and executed. One of the local dailies, I believe it was the Daily Monitor at the time, wrote and said that Colonel Semakula had commented before the trial began in the morning. He said, "We are going to try these soldiers and shoot them." Okay. The field court martial had been set up in 2001, some months before the incident, to handle indiscipline arising during a special military disarmament operation in Karamoja. And Colonel Semakula, who served as the chairman, was also the division commander. So ULS and Mr. Jackson Karugaba filed petitions seeking declarations that the entire proceeding was unconstitutional and that the soldiers had been denied every fair trial safeguard guaranteed by Articles 28 and 44 of the Constitution, including the right to an independent and impartial tribunal, the right to adequate time and facilities to prepare their defense, and the right to legal representation, particularly in a capital case, the right to an interpreter, the right to examine witnesses, and the right of appeal. Just think about it. These days, the DPP asks for 2 weeks to respond to a bail application. These soldiers were asked to defend themselves on a capital charge involving their lives within 3 hours. So the court's findings, a lot of the court's findings were important to the nature of a field court-martial, status of military courts and the applicability of the Constitution, the independence and impartiality of a field court-martial. And I think we know now enough about that after the Kabaziguruka case, and it's not the subject of today's discussion. On fair and speedy hearing, Honorable Justice Twinomujuni said that whilst the Constitution requires a speedy hearing, the speed must be measured against the requirement that the trial be fair in all other respects, and that a 3-hour trial from indictment to execution could not satisfy those requirements at all. There was a dissent by Justice Kavma. He chose to take the time as running from 22nd March to 25th of March. That was his contextual interpretation as the length of the trial. Make of it what you will. It just brings to mind why we didn't attack this on the basis of the 48-hour rule, because they were held for 3 days before trial. Okay, it doesn't show up at all in the case, right? On the right to the interpreter, Article 28(3)(f), the accused chose to speak in Kiswahili. The record did not specify who interpreted and whether the person was sworn to interpret faithfully, but the court concluded that there was no miscarriage of justice. But on that point, my recall is that the record of proceedings that we received was beautifully written and in English for proceedings that were said to have been conducted in Kiswahili. I don't recall that we took objection to that. On adequate time and facilities for preparation of the defense, Justice Twinomujuni held that they were not given any time to prepare their defense. They were dead. The trial started and they were dead within 3 hours. On the right to legal representation, there was a very interesting argument that the presence of the military officer called Captain Kagoro Asingura satisfied this requirement, but this was quickly thrown out on the basis that his role in the field court martial was to advise the court on law and procedure, not to represent the accused. Therefore, their right to legal representation was violated. So the court concluded that the soldiers were tried and executed without according them virtually all basic human rights guaranteed by Articles 28 and 44 of the Constitution. And he said that the right to fair hearing is absolute and one that must never be denied in any circumstances whatsoever. Right to life was also involved in this issue, in this case, but is not the subject of our discussion today. The petitions were unanimously allowed. All the justices agreed that the trial was unconstitutional. For different reasons, no monetary compensation was awarded. And Justice Kavma, interestingly, proposed orders requiring amendment to the laws on field court martials. You decide how long it took to make that. If we were to summarize the fair trial principles, I think we would say that number one, foremost, is that right to a fair hearing is absolute. It cannot be derogated from. And also, Article 28(3) is not exhaustive in what constitutes fair trial rights. Article 45 leaves the door open. It says expressly that the rights are enumerated are not exhaustive. Other rights are recognized in international instruments to which Uganda is a party, such as the Banjul Charter and so on. And on this, I must sound a caution about the recent Constitutional Court judgment regarding safe abortion, where the court said that they will only enforce rights which are expressly written in the Constitution. and not those which are sought to be brought in by implication. Please, I think it's women's pro bono. Please disregard that authority, attack it with everything you have. The court also, another principle is that Article 28 is a composite package. The denial of any single element of the Article 28 package renders a trial unfair. Speed, another principle is that speed must be compatible with fairness. The constitutional requirement for speedy hearing must be balanced with the overall requirement that the trial be fair. Unreasonable speed that compromises other fair trial safeguards renders the trial unconstitutional. I think we've covered the other points about mandatory legal representation, adequate time and facilities for preparation of a defense. Yes, there were also elements about the right of appeal, independence of the tribunal, which I've said we view as relating to the field court martial, which is not the subject here. I think on that note, I will thank you very much, ladies and gentlemen, honorable members and RNB, for giving me this opportunity to contribute to this discussion. I will be happy to take questions after the other speakers have presented. I thank you.
Thank you so much, Advocate Philip Karugaba, for those very, very deep and rather comprehensive remarks in regard to your experience in that time, and also your takeaway and the lessons and what you have told us in regard to what was a summary from that matter. We of course also take cognizance of the tributes that you have shared. We continue to pray that the deceased souls rest in eternal peace, but also appreciating the academia or those that supported you in the work that you did, Dr. Henry Honoria and OHT Makubia. We send our sincere regards for this continued support and partnership with the Ugandan Law Society in as far as ensuring access to justice and democracy are concerned. We are very critical in regard to listening into what you have just shared pertaining the general holding of the court to say that what transpired was unconstitutional and that there ought to have been amendments to the field court martial and its operations. But also very importantly, as we are in a very critical moment regarding mobile court sessions, the aspect that speed must be compatible with fairness leaves so much to be desired, having had you give an example or an imagination that nowadays it takes 2 weeks for the DPP to give a response to a statement or a matter before them, especially in regard to verification of documents. Say a national ID has been submitted by an accused, or an LC1 letter as are the requirements to be submitted for either objection or uptake, and the DPP is asking for 2 weeks, and then again as well comes back with an objection, and thereafter, after you have rebutted against the objection, the DPP will since again ask for another 2 weeks to make an inquiry. We're asking ourselves, is that a speedy trial? But what about 3 days? What about 3 days of a matter getting concluded, yet it tackles the right to life? Think about it. But also, the matter that Advocate Philip Karugaba participated in took 3 hours. Ladies and gentlemen, this is not something that we can take for granted, because those that were victims were either an uncle, auntie, father, mother, or rather father to, anybody who could have been amongst us, So it's very important that we have these discussions. And of course, we are going to continue with listening into that session and interrogate further questions regarding that topic so that we can have a session of question and answer. We appreciate you, Advocate Philip Karugaba. Thank you so much for your time. Your expertise is very, very much welcome to us, especially who are following in suit, in your footsteps, and we pray that God will bless you as you continue to work and operate and partner with the Ugandan Law Society. That is one of the sessions and rather topics and speakers who has laid a foundation in regard to the right to a fair hearing, and we want to listen to another individual who is with us in the house physically, who is a Ugandan legal practitioner under Kumbuga and Company Advocates and working with Social Justice Centers Uganda. He is a public interest litigator dedicated to advancing constitutionalism, access to justice, most especially in the criminal justice system. He is actively engaged in strategic litigation, particularly in constitutional law, where he has participated in cases addressing governance, electoral processes, and the protection of fundamental rights and freedoms. He is known for his bold and reform-oriented legal approach, often challenging policies and legal frameworks that he believes hinder democratic development and equal participation. Ladies and gentlemen, please welcome with me Advocate Katushabe Ronald, aka Justice Hunter. Excuse me.
The President, Uganda Law Society, the CEO, Uganda Law Society, our guests today, Uganda Law Society, lovers of justice, rule of law and freedom, I salute you all in the name of God and justice. Once again, my name is Ronald Katushabe, and as he has said, I'm also called Justice Hunt because I do believe we have to hunt for information in regards to abuse of justice and fight for justice. And specifically addressing the issue of the right to a fair hearing, whereby in our country, Uganda, it has become very hard to attain the same, like squeezing water out of a stone. So it calls for unanimous working hard for all human rights defenders, activists, all corners in our country, and the countries surrounding us to have the same achieved. As we talk about the topic of lawyers' roles, constitutional mandate, to make sure that we uplift, promote, and protect the right to a fair hearing, it inserts on us a big burden, one which calls for research, two, representing our clients, documenting, taking action to fight for these people. Not only the clients in our docket, but all Ugandans, and make sure these policies do stand. And when we talk about a right to a fair hearing, it involves a speedy fair hearing, and it calls for a hearing before an impartial tribunal or judiciary, as well as it's clearly articulated the Article 28, Clause 1 of the Constitution, honoring the presumption of innocence of the accused person until proved guilty, unless he or she has pleaded guilty. So it inserts the protection of such right and honoring that kind of mandate. But what do the statistics in Uganda do say? How is the response to this protection of the right? How many people are in prisons? The interactions we have had in prisons, I personally, visiting prisons like Ruzira Upper, Nakasongora, Makshon Bay, Kitaria, you find that they are overcrowded. Ruzira Upper prison, which is meant to have 640-something prisoners, it is in 3,000 plus. The same applies to Jinja Remand Kirinya Prison. The same applies to Makshon Bay Prison. So these overwhelming numbers, people do not go there. Prison is meant to keep prisoners. They do not determine when these people are supposed to leave or get in on the justice issue. And what we do first is that when we go there, so in cases of plea bargain, you find a prisoner telling you, let me enter this plea bargain because I have been here for long. I want to go home and be with my people. Not because they committed the offenses. And the challenges are literally where? In our country. Lack of enough judicial officers, lack of enough courts, lack of enough apparatuses to use in courts. We have had scenarios where prosecutors say, we are not ready to produce these witnesses. The investigating officer in the said file was transferred to another court, to another area. He was from Kampala, he's now in Kabale. We need more money to transport this kind of... The medical personnel who did the medical examination on the victim per police form 3A is not here. It needs a quite process and the engagements they do have to work on them. So it's a very, very, very challenging process. Following the case backlog history we have had, and we are still ongoing in our country, like when you go to court of appeal, and these mistakes do not only affect the systems or stakeholders of judiciary, but it goes hand in hand to the families of these people, and to worsen matters to find when these people are actually innocent. They say you rather acquit 100 people who are guilty than convicting one innocent person. We have had sessions. People are cause listed, yet they already passed on. You go to prisons, they say the person is on a cause list for a court of appeal session, but the person passed on. And it is denying a chance to other people that should have had access to this. Now, following the discussion of a right to a fair hearing, and from a firm where I work from, that's Kumbuga and Company Advocates, and we are so much centered in handling criminal matters, we feel a lot needs to be done. If we are talking about the discussion of mobile courts in our judicial system, it poses questions like, one, is Uganda ready to stand for the same? Are we in position to hold the same? I've been in scenarios where I've participated in mobile court sessions. Has been in Parabek refugee camp, that's in Ramo district, in Kiriandongo refugee camp, while working with some refugee agencies. And my discovery that these mobile courts, because of lack of preparation, there are a lot of observations and abuse of the judicial process. One, how? First, when it comes to the side of defense, starting with the accused person, himself is intimidated. He's intimidated, he's not even sure whether, since he has the right to present people, witnesses as defense, and himself defend himself. At times, because of the fear and the public pressure, he is composed to plead guilty, yet he did not actually commit the said offense. Because of the pressure and around. Because they started like happening all along in the north. When we were there, we discovered that SGBV cases, sexual gender-based violence cases, were at a climax. And you find that the only way, because of the pressure and the judicial officers to have these cases had only 2 days, because the judicial officer was coming from Chitugum Magistrate Court, Chief Magistrate Court. So you find the Chief Magistrate Court has to deliver the results that have actually handled many cases. And the prisoners are tasked to say, let us use this only opportunity to plead guilty or enter plea bargain. But the question is, you didn't actually commit the offense. But because of the intimidation you have been brought around, and you told your witnesses around, they say, you better enter plea bargain now. So you find that the intimidation denies you the fundamental non-derogable right of the right to a fair hearing enshrined in our Constitution under Article 28 and 44 of our Constitution, which is so shaky to our rule of law in our country. So the other observation is that when we have mobile courts, we know the mandate of the Uganda Law Society under Section 3 Act to protect lawyers. The intimidation of the lawyers already they do face from the public, because as a lawyer you are mandated to perform your role. We are mandated to defend these people and show to the public that these people didn't commit the offenses, but you're already facing the pressure from the public, limiting you on kind of questions you should establish in cross-examination of the witnesses, and the evidence you should demand for apply in scenarios like, one, if you want to have the evidences of the medical report for the victim or the accused person, you find that there is interference as why you ask for these kind of things and following the less time you have. Because if you are to apply for a medical report, it's another kind of process. Medical examination to be conducted on either the victims or the accused person. The accused person, entirely you're looking at issues like, one, were they tortured? Are they mental okay? Do they stand to be of sound mind? So you find the pressure that you're facing from the judiciary by then under those mobile courts and the public itself. It's hard to even create room for you to have all this kind of preparation for defense. So it's a very, very intimidating challenge when it comes to defense. When we are handling the mobile courts, the other issues is security. Because you have put this thing in the concern of the public. You're trying your best. And it's very hard for one to associate with a hungry and angry crocodile in water. You are open with people in the public. People are already angered. People are already hungry. They are saying you're actually delaying the process. We wish you can apply for bail and we have this person here. We do the justice in the way we do feel. But justice is a natural principle. That everyone is entitled to that fair hearing. And evidence has to be adduced by the prosecution to prove that actually this person committed this offense. And it is very much hard to put it to the attention of the public after them having already made their conclusion that the person committed the offense, that via the evidence the person didn't commit the offense. You find that the evidence being adduced is not much to prove that the person actually committed the offense, which is the primarily principle demanded under the criminal proceedings. So following those kind of challenges, that as a lawyer, you have lacked clear protection towards defending your client in time. Because you find these are sections, if we give examples, saying the ongoing cases, the outgoing cases that we have had experience, you are with the prisoner. At times we do an engagement, depth interview with prisoners when they are in prison. So you will not have room to interview this prison because here this is something being done in the public. You would need to go and interact with the prisoner in prison. But they are saying a session is resuming day per day. You are here today, you have to resume tomorrow. You cannot interview the prisoner at night. The prisons here in Uganda have had a standard of saying by 4 p.m. visitation closes. And they are following their protocol of security. So you find that adequate legal presentation to the accused person is actually also denied. We also look at other scenarios that proper recording of these cases is actually intimidated with. And it's hard to arrange proper record of court proceedings, if you intend to appeal or apply for revision on such kind of matters, following the setup of the mobile courts, the registry, the system, we are now on issues of ICMIS. So you find you are in the site where ICMIS doesn't connect. There are network issues. You have to comply with documents. So the issue is that the preparation for also having it in terms of the registry stationary working is also another kind of problem with mobile courts. And the issue is the emotions at hand with the people in the public. If you pick cases soon and soon, following the emotions people have in the public, the fear people already have, the pain they already have, as swift as that, you're actually attracting more hatred, which lead to biased judgments. Because as judicial officers, you find that you have to compare with what is coming from the public, politicians, and the judgment you have to deliver following the evidence you have on record. So it's a very, very big, challenging situation. And we as a team would like to say Uganda is not very much ready for mobile courts. And if it has to do so, it has to be in maybe certain cases where they have confirmed, if it's the prisoners who would want to enter plea bargain and they negotiate for the offenses. Information has been addressed to them some time back. They have showed their interest. They have registered for these offers. Then these ones can go there. But you can't say you are conducting a full hearing over a prisoner and someone witnesses and you want a matter to be heard expeditious in only 2 days, in only a week. That would be so unfair, and that would be an abuse to a right to a fair hearing. And would make some humble proposals that if we are to look at the doctrine of separation of powers, the legislature, judiciary, and the executive would recommend for empowerment of the judiciary. Because all these things are all done following the political influence to the fear of saying that they are dealing with issues of case backlog. So if there is respect for the doctrine of separation of powers and servicing fully the judiciary to perform its work, mandating that maybe if it is high court, you have enough high court circuits which are effective and efficient to deal with cases at hand, that would be something reasonable. Would be much obliged to find Uganda having each district a high court than having this nonsense of having many MPs in parliament whose mere role is to legislate. The demand is that the implementers should be many. You can have a few people to direct you where the fish is, but you need many people to harvest the fish. So the implementation of judiciary needs more support in terms of services, in terms of resources, and in terms of more empowerment. We are looking at the upcoming of the new Chief Justice. If they are talking about Court of Appeal and dealing with those overwhelming case backlogs, regardless of saying they are having these circuits, but we still say they are not the same. The case backlog Uganda has, even though you say you deliver judgment per day, you can't finish them in a year, even in 2 years. So the problem goes to the issues of respecting the doctrine of separation of powers. That as the executive, if we are saying we are there to honor justice being implemented as a hand, can we please look at avoiding creating more numbers in the political sector and open up room for the judiciary to say that they administer justice as its mandate under Article 126 of our Constitution. So that this is a call where you have, I come from Kakumiro district, you have 4 MPs, including the woman MP who is the Prime Minister, Robin Anabanji. But the question is, how many magistrate courts are there? Many cases are being pushed to Hoima. Kakumiro has a state attorney operating under Kibale, operating in 2 districts. So what pride do we have in owning positions administratively than actually ensuring that there is a river of justice to our people? So as we lawyers, we have to continue with the mandate, fight without fear, considering the motto of our country, for God and my country, and where God has always said that our role is to fight for justice. A pride of every human being is in fighting for justice. And that's why Proverbs chapter 31 verse 8 to 9 has always been very clear. Stand up, speak for those who cannot speak for themselves, and stand for justice. It's very clear. It warns us from living a luxurious life. Because before that verse, it says, do not spend your money on women and sex. They have ruined the people. Focus on the fight for justice. Still in the book of Psalms, 106, 105, it talks about justice. Everywhere it's justice. So our mandate that as we stand in for the poor people, they do need justice. And we are dealing with the oppressing sector, which would want to use the law to exploit all those in power, to exploit these other kind of people and their interests. So we have to make sure we fight for the rule of law, we stand for justice, and make sure that we take in actions like these situations of saying mobile courts, and in scenarios where are they necessary. You look at the distance from court to this place. Mobile courts should be established in a distance far away. And by the time you establish them, be aware of the services. Very shocking, 2024, in Parabek, we waited for a session, the session commenced at 1 p.m. Do you know what the problem was? There was no government vehicle to transport the prisoners. They came walking with the prison officers. You can think from Ramo district, Chitugum, from Ramo up to Parabek refugee camp. That's so humiliating, and what kind of state are we proud of? Or to have MPs and ministers who swear in their suits, but yet people are behind suffering. The pride of country and leadership is always, show me your country and I show me your leader. When people are well embraced with justice and peace and development, it means the leader is sensible. So these are questions we have to always highlight and put into our minds and work towards the fight, advocacy for justice and the right to a fair hearing. And we condemn the unreasonable setup of mobile courts, the abuse to the right to a fair hearing, and we insist on the demand for protection and promotion of a right to a fair hearing. Thank you so much. Once again, I'm Ronald Kashabe.
Thank you so much, Justice Hunter. That is a very deep discussion of the topic, and it gives more light to what was shared earlier on by Advocate Philip Karugaba, and we are so grateful for your outspokenness, especially in regard to the role of lawyers and the courts of law in as far as ensuring a fair hearing is concerned. These are very critical topics. The Ugandan Law Society, through the Radical New Bar Governing Council, is ensuring that this information reaches out to the members of the public, especially those, of course, that have either been a victim, or those, of course, that you never know what will happen, because none of us is safe in this country. You need to know, you need information, and this is what we're trying to do. And we'd like to think, maybe pick a few highlights from what he has shared, of course, because what he has shared has been quite critical. He has traversed the country, giving us examples from Palabek and Kiriandongo, that is in the refugee settlements. And of course, if you just look at it perspective-wise, how difficult it is for prisoners to walk such a distance, 30 kilometers or more. I can't imagine. Court normally starts at 9 a.m. and we're dealing with a court session that is beginning at 1 p.m. You feel for the advocates maybe who traveled from Kampala and have to return if the journey were meant to have begun that day. And of course, the intimidation that the prisoners are going through as legal aid service providers. That is one of the work that the Legal Aid Project does, of course, at the Ugandan Law Society. We have had situations where we've had to be discussing with the prisoners as to plea bargain. And plea bargain, of course, also ensures that the prisoner or the accused goes out free because he has committed or has accepted his guilt and gets into a negotiation. But we're asking whether it is a fair reason for him getting out, for him to say that he or she wants to get out because he has spent a very long time in court, in prison, and he's never been released, and he's only there for mention. Of course, we have also heard, especially about what the general public has been asking for, a speedy trial, but we are saying in today's session what amounts to a speedy trial, and should a speedy trial only be considered as a speedy trial because it has taken 2 days, 1 day, 3 days, whereas the accused person's life is at stake, and yet most likely he or she hasn't gotten representation and or needs the time to understand, because that relationship between the advocate and the accused is very important. That especially adds to what we call the fair hearing. We have always been taught and presented two such important international instruments by the President, Senior Counsel Isaac K. Semakade, while in his leadership, about the IBS standards for the independence of the legal profession that were adopted in 1990, and they go ahead to guarantee the protection of lawyers, because we're discussing the role of lawyers and courts. And of course, particularly now we're speaking to lawyers, we'd like to give a shout out to all the lawyers that have joined us online especially. Thank you so much. I can see the numbers are not so small. On X, we've reached 100 members, and that is, of course, very important for us to share. And whereas the IBA standards read, just in the preamble, whereas the independence of the legal profession constitutes an essential guarantee for the promotion and protection of human rights and is necessary for effective and adequate access to legal services, it goes ahead to give us standards as established by the International Bar Association to assist in the task of promoting and ensuring the proper role of lawyers, which should be taken into account and respected by governments within the framework of their national legislation and practice, and should be brought to the attention of lawyers, judges, members of the executive and the legislature and the general public. Of course, particularly, we are trying to look first at the rights and duties of lawyers. We have it in Article number 6 of the standards, subject to the established rules, standards and ethics of the profession. The lawyer, in discharging his or her duties, shall at all times act freely, diligently, and fearlessly in accordance with the legitimate interest of the client and without any inhibition or pressure from the authorities or the public, especially in regard to whether the accused is proven guilty or not, because remember, it's a fair hearing, and the presumption of innocence, as elucidated by Mr. Ronald in Article 23, the lawyer is not to be identified by the authorities or the public with the client or the client's cause, however popular or unpopular it may be. It doesn't matter the matter before the courts of law. Every individual, me and you, those that don't have lawyers, are entitled to an advocate, whether the crime, the alleged crime, is grave or not. A person is entitled to a fair hearing. We thank you so much, Ronald, for bringing these issues up. The protection of lawyers is very important. We are calling upon the lawyers to be confident, to be fearless, and be a justice hunter, especially as you are defending the victims, because of course without the lawyer, then the victim is doomed. Remember, lack of representation has a lot to do with how the case will go. You will never have an individual sharing with an advocate and expect that the individual will defeat the advocate. That is something that shouldn't be taken for granted. Imagine the state attorney having to operate in 2 districts. That's in Chikumiro, Kakumiro, and Kivale. That also means there's going to be a very big case backlog, because one state attorney who can only do so much cannot guarantee access to justice, and in that regard, a fair hearing. He has left with very, very strong closing remarks by quoting for us principles and scripture from the book of Proverbs and Psalms, generally asking us to stand up and speak for those that cannot speak, so as you can achieve your general objective of being on this earth, especially as you are an advocate. Ladies and gentlemen, we want to thank you so much for continuing to be with us. We have come to the end of the second guest speakers session. We were expecting to be joined by Advocate Stephen Kalali, who had indicated his presence and his attendance. However, due to reason beyond his control, he has communicated that he's not able to join us and would like to apologize on behalf of the program setters. That is normal, and of course we're also seeing that it's a rainy day out here. We never know what could have happened, and we render our apologies on his behalf, and would like to use what we have with us in order to continue the day. However, beyond that, we are going to now move to another session. Yes. We are moving to another speaker that is supposed to speak to us from a non-lawyer perspective. We want to try to put experience to the protection of a right to a fair hearing. And we're going to have an individual who has been through the gutters, you want to call it, especially in regard to the corridors of justice, and ask questions of whether he had a fair hearing, what his experience was, and whether it is commendable to go through the processes of police, prison, and anything to do with justice. Ladies and gentlemen, we are going to be listening to a journalist with over 2 decades of experience in media, specializing in crime reporting and investigative journalism. He is the founder and chief of strategy for TV10, Gano Mazima, an independent online platform known for covering current affairs, politics, and social accountability issues. He has worked with several mainstream media, including CBS FM, Gwanga newspaper, NBS TV, and NTV Uganda, where he covered crime, governance, and human interest stories. Ladies and gentlemen, please welcome with me Mr. Dean Lubowa Sava. Thank you.
Good morning, ladies and gentlemen. It's my pleasure to be part of this gathering. However much it came at a shorter notice, but I couldn't hesitate, despite the fact that the work done by this institution, Uganda Law Society, it's the reason why now I'm outside behind the bars and even given back my freedom. I will not go back to introduce myself because has already made it clear. Other than saying one more name which is remaining and makes people get scared, I have my tagline name which is called the Jemberi Akuno. When I stood out to defend the voices of the voiceless, I fear none. In Uganda, where we all demand for rights and even freedom of speech, it's where I follow much. I am a journalist. I served this country for almost 20 years. I started my journey in 2006 when I joined the CBS. The word investigative journalism was totally like a curse in our country. And we were only listening to people like Andrew Mwenda, the likes of Charles Onyango Obo, who used to do the kind of work I'm doing today. Little did I know that at a certain point I will also be those who are not liked in the society and even living a lonely life where you become the most hated person for speaking the truth. I will give a scenario. There is a certain time when I was covering a story and I tried to confront a certain general. I told him that, you know, even those people who are incarcerated, they also need their rights. The gentleman boldly told me that, you know, everyone has a right like a fish in the lake, but it's only the person who takes it out has a right and the right time to take it out. So in Uganda, we have a constitution and everything is available. Based on the previous speaker, he talked about the issue of pre-bargain, where I fall a victim. I accepted pre-bargain not because that I committed those offenses, but spending 6 months in prison without having a fair trial, I was just facing persecution, not prosecution. To the extent that there was a time when prosecutors from the other side saying that, okay, let's first go and consult our boss whether he's now okay or he has reduced his anger against the accused person who was me in the dock by then. I was prosecuted in the court which I was not supposed to be prosecuted in, because the standard utility court is for those who are hunters, for NFA, Umeme. But imagine a journalist like me who has covered a story of where a person took 11.7 billion in a contract to construct a road, and he didn't do anything. He just moved away with the money, buy his own properties. When I covered that story and I'd wanted to get a fair trial from his side, the gentleman sent me his colleagues who were my uncles, some of them, and were offering me 50 million. I refused to take the money. What next? He doubled the money to make it 150 and send a colleague of mine again. I refused to take the money. When I refused to take the money for the second time, he turned around and I just hear guys calling me that we have a complaint here where you need to come and present yourself. And the same person who was claiming that I've defamed him is the same person who has also taken a case to court. And I asked them now, where should I present myself? Because they are calling me to court, is sending me people to give me bribe, and you're also calling me to attend your hearings. I put it in writing with my legal team, but what the guys did, I just found myself one day, they raided our offices, come with 65 army men in full combat of military, and confiscate all our equipment, which was worth 400 million. Because ever since I retired from the mainstream, I decided, and I'm among the founders of the digital media in Uganda. Far back in 2017, when everyone was not even aware that we can practice our professions via the digital line. After confiscating all our equipment, again they said that we need to have a dialogue. We went in that meeting, but it was not a dialogue, just to sit here like a speaker, listening to what is coming from the other side, but not giving your side. And after that, a week after, early in the morning, 7:30, another raid at my office. Come with burglars, what? They break into my office and took me. Not even making a statement. They have already aligned their courts. By the time I reached to court Machinde, they told me that I have no right to seek for a bail, but I'm supposed to be remanded to Luzira until further notice. Imagine, you have not committed any crime, but just speaking the truth. That's when I came to know that even refusing a bribe in Uganda, it's an offense. It has made me to spend 6 months in prison. If it wasn't Uganda Law Society, because I had a legal team, they presented me for the first 1 month and the second one, and they started dropping by numbers, one by one, saying, issues are done in Pamvu. We don't think that is going to come out now. Until when President Semakade sent a gentleman whom I can't recall the name right now, seeking for my permission to represent me in my case. I think it was Mr. Allen. He accepted, and the person who directed them to come to me is now also behind the bars, Council Mabilizi, Mare. Then we reach a point that even the magistrate was saying that nobody can win a case in my presence. And the only alternative which I was supposed to take so that I can get back my freedom was to accept a plea bargain. What is happening in Luzira? It's just a total mess. There are so many inmates down there who even doesn't know when they will appear to court. And even the OC is not even bothered to consult judiciary as to why these people are rotting in prison. If we add on even the issue of ignorance within our society, it has also caused a lot of issues. To the extent that during my time in Luzira Maction Bay, I took initiative to investigate the prison itself, because I found myself that I couldn't go out as I was thinking, but the only option is to continue practicing my role, even if I'm jailed in. By the time I was in Luzira, I found out that you people, you're busy complaining about the backlog and even people not being presented in 2 courts of law, but you forget to address the issue of the birth control program, which is facilitated by certain projects, and they decided to work with police, prisons, and judiciary so that they can achieve their goal. For example, in Luzira Maction Bay, we are over 3,000 inmates. Me, I've spent 6 months there. If I was out in 6 months, I think I could have given birth or impregnated any woman. But imagine, the entire prison is holding over 70,000 inmates. who are rotting down there, but facilitated with an agenda of keeping them there so that they can control the birth programs which are going on. This is an hidden agenda taking place, and nobody is even bothered about it, because they failed to convince the society with family planning and other issues. So they decided to facilitate. And there is a time when even the OCs are calling the DPCs from the police stations, please, it's now high time to send us. We need to go. It's a rainy season like now. They have to send in people so that they can go to farms and dig and support them. And at the time when you guys realize that, it will be too late. Because these people, they need money better than defending our rights. It's a racket working together. We talked about the issue of pre-bargain. There is no pre-bargain. It's just forcing you to sign the documents so that for them they can make their maxes. Because any magistrate or a judicial officer, when they convict you, for them they gain maxes. I went through a lot. To the extent there is a point when they even forced me to get out of prison to bring me and attend a meeting where I'm forced to sign the documents so that I can get back my freedom. Guys, Uganda is not safe. And no one is safe. Imagine I was in prison. Guys were busy writing on social media via my accounts that I'm apologizing, and I was wondering, did I apologize via dreams or what? And by the time I moved out, all my accounts were hacked in, and the society was busy convicting me completely. The reason why I'm still keeping quiet, they say that I operate without having a license. By the time they took me to prison, I had already paid the license in 2024, and they refused to give me the license because of the nature of the work I'm doing. And as I speak today, I've already applied for a second license. They refuse to give it to me. So you live in a society where they curtail your rights, and they don't want you to continue practicing your profession, and again they are claiming that they are protecting the country. Now I fail to understand who is right and who is wrong. Because as I speak, I have even the receipt here. I paid my money for the second time. After having that, getting information that some of them wanted to give away my name of TV10 to another people. They called me for a fair hearing again. I attended. And the people they paraded there, after finding out that they can't take away my name, I've already registered it with URSB. The gentleman told them, okay, give them another license. And that has happened within 2 to 3 days. But now it's coming to a month and a half. I haven't received my license. When I resume operating, again courts will come and say that I'm operating without a license. So we are in a society where people think that giving you what you're supposed to take, it's just their mercy. People hold government offices and turn them into their personal ventures. We can't claim freedom of speech or fair hearing, like as the theme is saying, when people are working under fear. Because we may reach a point where some of the colleagues within the judiciary telling me that, you know, man, even if you apply for bail, you will not get it. Before being presented to court, we receive calls every morning telling us that we should not give you a bail. So you only have one option: accept a plea bargain. And I had no reason, I had no any other alternative other than taking a plea bargain and regain back my freedom. My coming here is just to say, I would like to thank the Uganda Law Society, Council Robert Jurua, Council Kamkama, and much more so, President Isaac Semakade. I will not forget to thank the first legal team which presented me, Sama Hamia, and even Kaganza and Company Advocates. They did their part, but the guys overpowered them. But Uganda Law Society stood with me until the last minute. If we have such organizations within our country, I think we can achieve our rights. But if we don't have such, and if they are not funded well, they will also reach a point where they will not be able to stand with us. I will not have much to say, but my humble request: let's work together. This country needs us better than those who are in power. We are the future, and we are the present. We can't live in a society of fear. These people, they also fear us. But just because that we are still ignorant, or we are not yet ready for what we're supposed to do. My name is Dean Lubowa Sava Sarongo. I came here on behalf of TV10 Ngano Mazima. I send my greetings to each and everybody who attends this session. Let's keep hand in hand to protect our country. If we don't fight corruption, we can't achieve anything we want in the country. Thank you.
Rnblive is the name that he said. I forgot. Would like to thank you so much, especially for your astute presentation of your actual experience in the courts of judicature that took you from your workplace, the trade that brings food on the table, helps you look after your family, to the courts of law, to the prisons, which of course has given us a route to appreciate aspects of a fair hearing and whether or not we are actually living the life that we had anticipated in as far as the aspects of justice and fair hearing are concerned. We are left to ask questions as to the extent of the right to a fair hearing being lived in reality rather than a constitutional promise, because it is offered and provided for in the Constitution. We're asking questions of what is the ethical duty of a lawyer when the law appears to serve injustice. We sympathize with the legal team that you say was overpowered by the state in regard to the completion of your matter. We ask the question whether the judicial independence is under threat, or whether we are witnessing unnecessary state control. If you say you received calls, or rather you are being notified by judicial officers that they are being told to deny you bail and you shouldn't even bother to apply for bail. And these very intriguing questions are asking whether or what reforms we urgently need to put in place in order to restore public confidence in the judicial system, because Mr. Dean Lobowa Sava, a GenZ Lyakuno, is a mere citizen who is not a lawyer and has experienced a scenario where he is wondering whether the judiciary is independent and whether or not he is able to believe and trust in the judiciary. And the question we have for lawyers is, how should we respond to prolonged pre-trial detention and procedural abuse? If you were in jail for 6 months, even without being given the opportunity to apply for bail. So the questions are lingering, and that is the purpose that we have these sessions. We, of course, as the Ugandan Law Society, would like to appreciate you for trusting us to deliver you from out of jail. It's not something that we are going to necessarily sweep under the carpet, because it was also a back and forth session. I was privileged to be among the team, and it wasn't an easy task, but of course we thank God for listening into our prayers, and also the Ugandan Law Society for playing its role and mandate to ensure access to justice by helping citizens where representation is not. And to all the other lawyers, of course, would like to thank you, and would also like to appreciate you for the confidence to come and speak. You know, your experience is supposed to speak to the members out there of the public, and also to encourage lawyers to know that they are individuals who are meant to help access to justice. The theme for the day and the first session has been the role of courts and lawyers in as far as ensuring access to justice is concerned. So would like to use this opportunity to re-encourage the members of the society and the lawyers, of course, and of course as well the judiciary, because we continue to remain sisters in this struggle to ensure access to justice. There are always level-headed judicial officers, we can't deny that. There's always independent-minded judicial officers, and we pray that the Lord will touch the souls of those that are seen otherwise, in order to come back to a moment of normalcy to ensure access to justice. I thank you so much, ladies and gentlemen, for continuing to be with us. While we were at it, we were joined very much by the acting secretary of the Ugandan Law Society, who has come through amidst his busy schedule. We are very humbled to receive you, Counsel Babu, who is here with us, and we shall of course want to extend the microphone to you at some time in order to help us understand and receive regards from the council that is in government. We're also joined by one of the guest speakers for our next session, which of course is what we are going to go into. We shall be having a moment of question and answer for the two different sessions at a go, in order to allow the other session to go on, and also to catch the time that we lost earlier on. And nowadays, we know very importantly, everybody is a little busy, and of course the weather is not nice, so we'd like to cut to the chase and delve into the next topic, which of course is also critical to our nation right now as we talk, because it reads political prisoners as the site of struggle for the GenZ, Uganda GenZ movement. And of course, the preamble is to the effect that the question of political prisoners has increasingly become one of the most defining justice issues of our time. Across the country, there have been several reports of enforced disappearances, arbitrary arrests, prolonged periods of detention, especially because of differences in political affiliation. This raised serious questions about fairness, due process, and equality before the law. At the same time, we are witnessing a remarkable shift in civic engagement, particularly among young people. The Uganda Gen Z movement has emerged as a visible force in demanding accountability, transparency, and justice, with the issue of political prisoners becoming a central point of mobilization and advocacy. For many young citizens, the detention of perceived political actors is a symbol of a broader struggle for constitutional rights, civic space, and the protection of fundamental freedoms. Now, this discussion, therefore, invites us to examine not only the legal realities surrounding political detention, but also the social and generational forces shaping the current moment. It calls for a sober reflection on whether the justice system is being administered in a manner that inspires confidence among young citizens, and whether the constitutional promise of liberty, fairness, and equal protection under the law is being realized in practice. It's a very tricky and complicated, yet simple to understand topic, and we invite us to open our minds and receive this discussion from our panelists who are going to be taking us through the second session of the day, and how we can go up. We were supposed to open this session by the help of the president of the Ugandan Law Society, Senior Counsel Isaac K. Semakade, who was supposed to be joining us online. I would like to confirm with the IT if he's online. If he isn't, I'm told he isn't yet for whatever reason, could be technical. In the meantime, we invite an individual who is an advocate of the High Court. He currently serves as the head of the legal department and secretary for legal affairs at the National Unity Platform, and he has been a key part of key Supreme cases, including the landmark case of the Attorney General versus Kabaziguruguka. So we are going to welcome with us, ladies and gentlemen, Advocate Jonathan Elotu, who is going to open for us the session, after which we shall get to hear from the others. Ladies and gentlemen, Advocate Elotu Jonathan.
Thank you, everyone. The man has said so much about me, even I may fail to say, maybe, anyway. Thank you, everyone. Good afternoon, everyone. I thank everyone for coming here today. I thank the Acting Secretary, Mr. Babu. I also thank the other commentators who have been here with me. My topic it looks a very simple topic, but it is a very big topic. Firstly, it is always very bad for someone to wish you to be behind bars. Most of the times, as Dean Luwa said, that you meet these people, you know the people who are taking you to jail, and they insist that you have to be behind bars. Even if you bargain with them, even if you tell them that, look here, we can have a settlement, we can have a discussion with you, they most times insist that you first go and spend time there. When you come back, that is when we shall discuss. So there has been now a trend in society that civil cases are now turned into criminal cases. You would, if Dean Loboa, of course, had committed those offenses, you'd think that the best court to take him would be a civil court. Charge him with defamation. Say he defamed the gentleman, and then have your day in court. But because they know that a civil case does not move the way a criminal case does, a criminal case, the first thing it does is to take away your rights. That when you're taken behind bars, the first thing that goes is your rights. You'll be taken to Luzira, and now it is in principle that the first time you enter court as an accused person, the only time you come out is after, first of all, going to Luzira. Previously, you'd go to court today and then get bail on the same day. But right now, you go to court today, you'll come out at least after 1 month. That is if you're lucky. In our country, we have about 3 types of prisoners. The first type of prisoners are those who are convicted. Someone who has done an offense, he has gone to court, and court they have laid evidence against him, and they have found that he has committed that offense. That's the first type of someone who is a prisoner in this country. The second are those guys who are on remand. An accused person, they're saying you've committed an offense, you have your right to a fair hearing, you're taken through the process of court. Later on, you might be found guilty or not guilty. Those are the third type of prisoners are civil offenders. You have failed to pay a loan, you're picked, taken to court, court finds, yes, you really failed to pay the loan, you're taken to court for 6 months. Those are the third types. But there are also the other types of prisoners, that those prisoners who are in prison not because of the crimes they have committed, but because of their conscience, because of their belief. Those are the prisoners of conscience. That is where most of the political prisoners lie. That most of these political prisoners are arrested and picked for having been part of a political party. The political party that I come from is the National Unity Platform. So you'd have some prisoners or some people who are picked up by police, by JAT, by the military, and taken to courts. These are the types of prisoners who are political prisoners in nature. So this type of prisoners normally prefer non-violence, and they're not normally peaceful in nature. So an example of such a type of prisoner would be someone who is on social media, TikTok, and saying what the government has done is wrong. The government shouldn't do this, the government shouldn't do that. Case in point is Dean Loboa, because it's here. You're picked up, taken to court. From court, you pass through the system, you're taken to jail. Because of your belief, because you believe that what the state is doing is wrong. And you have a right to say that. You have a right to say that what the state is doing is wrong. Actually, even the case of the constitutional case of Andrew Mwenda was very clear on that we have a right to actually disseminate wrong news or wrong information. We have that right, but right now, that right is no longer there. You cannot even go to court and start arguing that I have a right to disseminate wrong information. For you, they'll say you've admitted to the offense, you've conceded to the offense. Like, we're living in times where activism has become really, really hard to do. To be an activism right now is an offense. We go to courts every day and we see that you're arrested for activism. You're not arrested. You're abducted for activism. We rush to High Court, apply for habeas corpus for you. Attorney General brings an affidavit to court to tell court that you were not picked by the military. To tell court that they have checked all the police cells, they have checked all the detention facilities, they have even gone to prison and you're not there. But people saw you being taken. There's a video maybe showing that the military came and picked you. But the government is saying they do not know where you are. John Mary Sebofu, our deputy presidents. Later on, you're taken to court after having spent about 3 weeks, a month, behind bars in the detention facilities. Taken to court. From court, the system is you reach court, the first place you reach is Luzira before you start speaking. State will either not be there that day. If state is present, the magistrate will say she's not or he's not the one handling the case that day. But the next time you'll still get them handling the case. They'll say, my instructions are just to adjourn this matter. You're given your 2 weeks or a month. You come back to court. From court, you ascertain whether you can apply for bail. You apply for bail. Bail takes, they start dilly-dallying on bail, whether to grant you or not to grant you. Lawyers start going to the chambers of the magistrate. Please grant him bail, grant her bail. It's in the best interest that you should grant him bail. Then judicial officers are telling you we should let it first cool down. There's a lot of fire. Let it cool down. But this we're dealing with the right of a human being. Someone is behind bars. Someone is going to jail. His rights are taken away from him. We start now talking. No, okay, this time around, let's not grant him bail. Let's grant him the bail the next time. So we are stuck in that conundrum. Stuck in a conundrum where the law is not assisting you. You want to use the law inside, it is no longer the law, it's politics. Speaking on politics takes me to the general court martial cases. As you may know, we had about over 100 people. We had over 100 people at the National Unit Platform who were having trials before the general court martial. Then we had the Supreme Court declare that the general court martial cases, or the general court martial per se as a court is a kangaroo court, which of course they also have a problem with. They do not want us to say it's a kangaroo court. But those cases that were before the general court martial, those people have currently spent about 2 years past the general court martial decision. And mark you, it is not that the lawyers do not have a solution. We do have a solution. But the solution has become political. We have applied for bail for those general court martial cases. We first of all applied for Aaron Chiza. He was lucky that he was granted bail. Several other cases came after that, and they too were granted bail. Later on, jurisprudence changed. High Court decided that the best court to hear this matter was not the High Court. Mark you, this is a High Court with the unlimited jurisdiction to hear or handle anything. The High Court says, we do not have the jurisdiction to handle these cases. We ask them, who then has the jurisdiction to handle these cases? If it is not High Court, who then? They tell us, criminal procedure has a procedure. You first have to go through the committal proceedings. Committal proceedings of over 100 people. That means DPP has to sanction the files. But how does DPP sanction a file when the military had a charge? The military thought there was a charge that these people had, there are offenses that these people had committed. After committal proceedings, to them, that is when you apply for bail. DPP is not interested in the files. We have written so far 3 letters to them. They're not interested in the files. We have had engagements with them. Nothing has come out of it. A person is in jail, a legal conundrum. The lawyers cannot help you. The court cannot help you because the court has said, let DPP handle. Let DPP sanction the files. Let a magistrate then start handling the file from way below. We see on social media and news that MPs now get relevance using these files. You see honorables trying to use these files to get relevance. But these are people's lives. These are people who are behind bars. Even if they committed these offenses, even if they did not commit these offenses, where are their rights? They were never sentenced by the other court, which was declared unconstitutional. No one is interested in them. So where does that leave an activist? An activist who knows that even when you're fighting for someone's rights, because normally when I meet them, they say, we're fighting for the rights of the afande who is arresting us. We're fighting for the rights of the magistrate who is remanding us. How do you fight for that person's rights when they look at you as someone who is trying to stop them from protecting the gains? But as a judicial officer, where does the humanity come from? First of all, we're humans. I know we make mistakes, but we're humans. Where does the humanity? Anyway. Then you throw away, if you put aside the judicial officers together with the system itself, you're then stuck with parliament. You have a parliament which is interested in having a decision, interested in legislating for the government. We now have the sovereignty bill, which I believe was tabled today in parliament. What does it look at? A non-Ugandan is a foreigner. I mean, a Ugandan who is abroad is a foreigner. Any money you receive from a foreigner, because my simple understanding of the civil procedure rules, an agent is someone who does something for you. You do not even need sometimes to file the powers of attorney to say this is my agent, but someone who does something for you. So if I receive money from a client abroad, I am an agent of that. I become an agent of that client, and that means I am a foreigner. I am an agent of a foreigner according to the law. I don't know how many people have 2 billion in their accounts, but they're accountable. The people who have 2 billion in their accounts to pay that money or serve a sentence of 20 years, there are very few. And I do not think most of our activists have that amount of money, because that is a lot of money. That law is meant to cripple any dissent. That law is meant to cut opposition. Basically, the government is left with one thing only to do, to say this is a one-party state. But I do not know why they have not yet done it, because everything is pointing to the fact that this is a one-party state. We are all just moving around in circles and not looking at the elephant in the room, that Uganda is a one-party state, that this is a country which is ruled by a family and by a group of people who want to stay in power forever. That is what we're forgetting. In conclusion, I listen to a lot of music, and I like, if you have listened to the song of Kanye West, Praise God. The song is called Praise God, but it quotes a speech by Gwendolyn Brooks. The first paragraph the first verses quotes that speech. Maybe I could read that speech to you. The speech is to the young, the speech to the progress toward. So it was basically a poem. She said, say to them, say to the downkeepers, say to the sun slappers, the self-soilers, the harmony hashers, even if you're not ready for the day, it cannot always be night. We shall win at the end. Thank you.
Thank you so much, Mr. Lotu. That has been a very candid discussion of the topic. Affects you personally, because at least we have had the privilege of working with you in regard to the predicament of the political prisoners. It's a conundrum, as you said, and we're not going to stop at it, because it is exactly what keeps us alive as we continue asking critical questions, whether the role of lawyers, families, and civil society played in this struggle, it will ever be recognized, and whether imprisonment weakening the opposition parties and opposition people will ever stop, because of what you just read, of course, as well as the experience of detention, because we've had all these experiences. We've been through the streets all together of course, in representation of the Ugandan society in courts like Kanyanya and Kawempe. It's not been a very easy run over there. We all know, if we have been following on social media, the stories coming from these courts of law are now despicable, not a very good place. We thank you also for describing for us the different prisoners, all kinds of prisoners, which of course leaves a lot to be questioned, because in any case, I think you're supposed to be only one kind of prisoner. You go to jail and maybe come back on mention, and in any case, that's even because you have not gotten bail. Bail is supposed to be issued in 1 day. So if you're going to be taken in for your dissent, and therefore the courts are already biased about whether or not you should get bail, is already a question to answer. And that is, of course, now linked with the right to a fair hearing, which is already being punched holes into. And of course, it leaves a lot to be desired. And Jonathan, you have fought this battle, and we really want to appreciate you, because we watch you, we see you. Of course, in your representation of the different, the legal department of the National Unity Platform and all the else, you have really stood the test of time, and we thank you for identifying with us, coming here to listen in, and also speak your different kinds of experiences. You have given us so much information, because activism has now become an offense from what you're telling us, and it's becoming a problem for you to oppose anything that the government is doing. And yet you said as well that that case of Andrew Mwenda allowed us to disseminate wrong information, not necessarily because you want to, but that is what you believed, as long as you can prove the source. And the event eventually doesn't have to make you a bad person. Of course, you've also identified individuals that have been in the struggle. John Mary Sebulfu, which is of course something that we are very sorry about, and we really try to, as much as possible, to sympathize. We had Dr. Zedriga here, who is the acting president, of course, who of course gave her story, her experience, which wasn't also nice. We also had the deputy president representing Western region for NUP, who also came and gave her story, which of course left us so much in question as to whether the parliament is legislating matters that are in our favor or not. And when you talked about the 2 billion shillings as a fine, I checked on my account. I saw number 2 was the first digit, but the rest of the zeros, I failed to reach billion shillings, but I have some of it on my account. I just hope it will never be time for me to release that money, and it's not enough, and I will be able to answer those questions. Yes, we are also asking that the lawyers, remember the topic number 1 was to do with the role of lawyers, but also we are saying that this is the time that these dissenters of government positions need to be supported, just like Dean Lovoa Sava, who was here, who has received some comments, I must say, received comments from Miss Namulindwa Shifa. Thank you so much, Miss Namulindwa Shifa, for identifying with Dean's story. She says Dean Lovoa's story is so sad, but this is the reality of the situation in Uganda. Thank you, Uganda Law Society, for always providing legal counsel to those facing injustice. Ms. Shifa, that is our work, but we also receive the flowers that you've given us, and we thank you. And in case you have any of those challenges, kindly feel free to reach out unto us in any way possible amongst all the lawyers who we have as our members, over 7,000. We also got a comment from Mr. Kagoda Samson. Mr. Kagoda Samson, thank you so much. Much respect to Senior Counsel Karugava. Yes, Mr. Karugava has once taught me that a senior counsel is not the way to refer to lawyers who have not yet earned the position or title of senior counsel. He teaches and says we should refer to them as advocates, or rather senior advocates. Yes, Mr. Kagoda Samson, in your reference, we would like to thank you for giving us feedback. We'd also like to acknowledge the over 130 participants that are attending online on X, something very important. You know, the topic has become so critical that our followers on YouTube, X and Facebook are very attentive. We're going to continue to release some of these comments to appreciate you out there, the media, the public, and the lawyers all together. But in any case, we are appreciative that you're here with us. We are coming to the next session that is going to be given unto us by one of the guest speakers. However, we got a request from Mr. Dean Lubowa Sava that he needs to be leaving the place, and we would like not to hold him. We'd like to request that the team that is before us, the panel that is before us, gather in front here for a group picture, which is our normal procedure, so that we can release Mr. Dean Lubowa Sava, and we shall continue to listen in to the different speakers. We've also been informed that the president of the Ugandan Law Society has finally joined us online, and we are going to be hearing from the president soon after we hear from the next speaker. So ladies and gentlemen, keep it hooked. Do not leave the tune. Thank you so much. Thank you so much, ladies and gentlemen. We continue thanking you for being with us. We are not going to spend so much time after that group picture has been taken. We would like to understand a few more questions in regard to the certain topic, which is dealing with political prisoners and their experiences, and whether or not the members of the public who are actually dissenting are getting justice, not just because of their reasoning, but also mostly because they are dissenting with what the government is saying, or a government department. And we're asking these questions like, who qualifies as a political prisoner in Uganda, and who decides? Are these arrests and detentions becoming tools of political control against the Gen Z activism, and especially how these experiences are determining the rule of law in Uganda? With us to speak to us in this regard, we have a pharmacist by profession. Yes, a pharmacist, don't get it wrong, who has served as the guild president of Makerere University in the year 2021, 2022, and she is currently the elected woman councillor LC5 Kawempe South. Ladies and gentlemen, please welcome with me Miss Shamim Nambasa.
Thank you so much. It is rather a big test to speak after very eloquent and intelligent people like one Council Elotu, but I do appreciate it, and good afternoon to everyone. My name is Shamim Nambasa, as introduced. I'm the elected woman Lord Councillor, Kawempe South, and the 87th Guild President of Makerere University, but most importantly, a member of the National Unity Platform. I am a pharmacist by profession, as clearly stated, but I am aware and I know that Article 29 of the Uganda Constitution does enshrine our civil rights, our freedoms as the bedrock of what we should live by in this particular country. It gives us the freedoms of speech, expression, and association, but it is unfortunate that as we speak today, we have many that have been locked away in gazetted and non-gazetted places because they hold particular views or because they have particular political beliefs that do not align with those that the people in leadership expect them to have. Having to speak about a topic like political prisoners for me is very sad, because for most of the people that we know who have been held in these particular prisons, right from 2021, 2026, we have seen mass imprisonment of people from the National Unity Platform, which is the party that I subscribe to. The likes of Edward Sebufu, the likes of Kaija Dorin, my age mate literally, the likes of Olivia Lutaya, the likes of Achileo Chivumbi, Honorable Mwanga Chivumbi, who hails from Mutambala, where I come from. But then also it's important to note that he was arrested with very young people, including students. And to date, they are still struggling to actually be granted bail. But so having to come here and speak on behalf of GenZs, I know that I'm speaking on behalf of so many that are being held in prison. I'm speaking on behalf of some that have been disappeared forcibly without us having to know where exactly they are. But then the question is, so then do we stop fighting because some of our colleagues have been arrested? Do we stop fighting because some of them are missing? I do not get to tell so many people, but on several occasions, I can say on a daily basis maybe, I receive a call telling me, aren't you afraid of getting arrested? You know, on so many occasions, I've seen some even going to the extent of making videos and saying, Nambasa, we have seen you, but we had the Nibandas. They started like you. Do you know where they are today? They have spoken of so many examples, people that have been poisoned, people that have been killed, but then also those that have been arrested. And maybe they expect us to stop to speak up. Maybe they expect us to do what it is that is expected of us. Some of them come as threats, but some come disguised as warnings to show that they care about us. But we believe that if they actually cared about us, then they would have paid attention to the issues that affect us, rather than paying attention to who is raising a particular issue. As the Gen Z movement, we do acknowledge and we know that we no longer have the bushes that we used to go to, that we had people went to. I mean, during their times, they went to Makerere and picked colleagues and went with them to the bush. But now we don't have those bushes anymore. We must know that we now have the modern guerrillas, who is us, the young people. We must know that we must fight. And that then means that while we are aware that some of our colleagues have been arrested, we recognize ourselves as political prisoners. We recognize ourselves as prisoners in our different spaces. We know that we have the corporate prisoners. We have colleagues that are suffering, but they are afraid to speak up. We have seen media that used to broadcast the truth no longer doing that, simply because they're afraid of losing or not getting government advertisements. They're afraid of their licenses being revoked. They want to protect their jobs, but they're protecting their jobs at the expense of our futures. We have those that have been forced into exile, and most recently our president, His Excellency Robert Kyagulanyi Ssentamu. He's in exile, his home was taken over simply because he dared to challenge the NRM or the Museveni government. As I stand here, I know that I was invited by Councillor Semakade, but he's also not here. He's in exile because he held particular views. So we do conclude that at the end of the day, we are all prisoners, only that some of us are out, only that some are in, only that some have been forced to disappear. But once we recognize that we are all prisoners, we then must know that we have to do what it takes. We have to fight. I saw a quote recently that said, I have seen graves of those that feared to fight because they feared to die. The sense in it is that at the end of the day, we are all going to be dead. So we would rather live speaking up or live on our knees, and we choose to speak up. So to the young people, we know, and the fear is there. Sometimes I also get it. But then when I look at what it is that we are fighting for, when I look at the future that I want, I know that we must keep fighting. It is high time that we started to embrace the different avenues that are available for us to speak up. We have social media, we have podcasts,
We have spaces like these, and I must appreciate the Uganda Law Society for holding that up. In a country where there is no longer rule of law, where the judiciary is an accomplice in making sure that Ugandans suffer only because they're exercising their rights. I have colleagues who are, even just getting bail is very difficult. I've been to Kanyanya on several occasions. And even if you fulfill all the requirements, they will still not grant you bail. We have had prolonged detentions. We have had trials not being commenced, and it is the judiciary that is aiding that. But then at least we take solace in the fact that we have an alive Uganda Law Society that at least still does uphold the law and is taking charge in saying that we have our rights being upheld. So as I speak, yes, shall we stop to have political prisoners? Definitely not. Because for as long as we continue fighting, they will continue to arrest us. But for as long as we continue fighting and increasing the numbers and enlightening those that do not know, and building capacities of more young people to understand what their rights are and what they must fight for, then we shall finally be free. I must appreciate the National Unity Platform for having started the Leadership School, because I know that those are some of the things that must be done to make sure that the GenZ movement continues to be alive with very informed people who are actually fighting for a better country. I started by saying that I'm a pharmacist, and on several occasions I've had people asking me, but as a pharmacist, what are you doing in these things of politics? I hear it a lot. On many occasions, some of them tell me, oh, we thought you're actually a lawyer, because they think it's only lawyers that are meant to actually fight. But maybe it is time that we made it very clear to the elites, we made it clear to the professionals that this is a fight for everyone. We saw the fight in Sudan starting with professionals much as it was hijacked. So please, as you fold your sleeves and continue to pay more and more taxes, that we are seeing ourselves getting into a time where we are asking the government to take the salary and we take the taxes, that maybe we now have to fight, that we need the professionals to actually come on board. This fight is for everyone. We must continue to actually mobilize for resources, because while many may not want to admit it, but at least there are some resources that are needed. We need to take care of the families of the political prisoners. We need to see that we are training people to understand what this fight is about, and we can't shy away from the fact that we need resources. We have seen our fellow people, our fellow party members break down when you visit them, because they're afraid of seeing what Ugandans are coming out to do. So it is important that we keep their spirits high. But then also, when it comes to issues of having legal support, I also must once again appreciate Uganda Law Society. We have seen them come through to help, but we need more legal support. We need more lawyers to take interest in this particular issue. And then maybe look at what happens to the families of people that have been imprisoned. What support are we giving them? What does the law say in that particular issue? Or maybe is it time for us to start seeing that the law does have elements that address what happens to the families of political prisoners? So we have a very big task ahead. We have a lot to do, but we must never stop fighting. And at the end of the day, as the GenZs, it is up to us, the families or the lives, the youthfulness of our grandparents was stolen away by this very regime. We cannot allow the same to happen to us. So I conclude by saying that this is a fight for everyone. As the GenZs, we have a role to play, and we must fulfill that mission, or rather, we will die regretting why we did not speak up when we actually still had the energy to do the same. Thank you so much.
Madam President, thank you so much for your very, very unequivocal remarks that are speaking straight to the GenZ movement, which of course is a message to over 70% of the population of this country, which I want to imagine is a message that has reached out to especially the people that are meant to shape the future of the country of Uganda, which is in the now. You have ably broken down what we are looking for, beginning with your understanding of why a pharmacist of all professionals is here speaking to not just lawyers, of course, but to the general public, but also how a pharmacist has been once at the helm of the mighty Makerere University, where we say aliuta continua. The struggle never continues, rather never ends, it rather continues, and we shall never stop to fight as long as we understand the purpose for which we are fighting. You have identified with the various gazetted or non-gazetted places of detention, which of course is something that we are very concerned about. When we were hosting one of the guest speakers a few months ago, we learned of a gazetted area, a non-gazetted area in Mulago at the police station, which we had never heard about. We were told Mulago police station has a bunker, something that was new to us, especially those that didn't know. So you can imagine how many else we don't know that are out there, that when they're looking for the prisoners, like Mr. Eloto was saying, at the hospital, at the prisons, at the police stations, none of them is nowhere, and yet they were easily seen to be taken by either individuals in uniform or not. And you ask yourself, we of course sympathize with the families of the political prisoners that have been mentioned, including Kaija Dorin, Olivia Lutaya, Ashley Chivumbi, Honorable Mwanga Chivumbi, that of course we have also identified with as the Uganda Law Society in as far as their detention and so seek for justice has been concerned. And we also of course identify with the late Honorable Nevanda Serena, who was a personal friend of mine. She used to associate and identify with the Democratic Party, and it still hits me hard as to what happened to her. But of course, we continue to pray that her soul rests in peace. You have termed us as the modern guerrillas that are not going to be picked from Makerere University anymore, but rather everywhere, as we are the majority in the society. So you're asking us to join the GenZ movement and help those that are not able to speak, but also warning them that when you fear to fight because you fear to die, you will be among the first to die. Because if the situation and the environment is not conducive for you, then you'll have nowhere else to run other than be victim of the system. To the young, you have spoken and told us that the future is for us to shape. We should embrace the avenues to speak, like these ones that have been created by the Uganda Law Society and all else, but also continue to interact with the Uganda Law Society and notified us that the fight is for everyone and not necessarily for lawyers. It doesn't matter where you are, who you are, and what you think. At the end of the day, if you're not able to speak for yourself, you will be picked, and no one at that time will identify with you if you did not identify with the people that are out there for you. Madam President, we are very grateful for your time. We congratulate you upon your victory in the most recent elections. We pray that Allah will guide your steps and guide your reasoning and give you knowledge, wisdom, and understanding to continue the fight that you have begun from the time of your childhood to now. Thank you so much once again. Ladies and gentlemen, we have come to the end of this particular guest speaking, and would like to continue to our last speaker, who doesn't need a lot of introduction and is going to help us to wind up on this particular topic so that we can delve into the last session, which is question and answer. And I would like to confirm if we have the president of the Uganda Law Society online. I am told he's online. I would like to welcome the president of the Uganda Law Society, Advocate Isaac K. Semakade, Senior Counsel. Mr. President.
Good afternoon, colleagues. Am I clear?
Yes, you're loud and clear, Mr. President.
Thank you very much. First and foremost, I bring greetings and compliments of the Radical Nuba Governing Council to our distinguished guests and panelists for the two sessions we've had today in full protocol observed. But perhaps exceptionally, I should mention Guild President Emeritus in our midst, Shamim Nabassa. You have been heartily received, and the world has been able to see that you're truly made of stellar staff. Thank you for giving us the testimonies. I would like to go straight to a presentation that I have prepared on this question due to its sensitivity. Comrade and colleague Jonathan, thank you for honoring this invitation from your busy schedule. You are very important on where we go from here. Political prisoners as the site of struggle for the Ugandan GenZ movement. What is to be done? The first thing is to bring into the public domain a definition of political prisoner as the collective, definitive, foundational aspect of our struggle. Or I should say, your struggle as GenZs. There is a definitional problem. I have heard Shamim say that, shall we stop political prisoners? Definitely not. And that's made me cry, because Shamim is committed to political freedom, but she lives in an ecosystem that hasn't given her a definition of political prisoner and an assurance that the world ended, or it thought it had ended, the scourge of political prisoners. So we must provide a definition. And as president of the Ugandan Society, I will put it in the record. A political prisoner does not emerge from ordinary crime. I think the two speakers have made that point. A political prisoner is born of political persecution, the deliberate weaponization of state power to crush dissent, silence ideas, like my idea of the right to incite and annoy leaders, and to punish the mere act of imagining a Uganda beyond the Museveni junta. Imagining, the mere act of imagining. And I think that's the essence of the bill that will get a first reading this afternoon. This is not mere rhetoric. It is the irreducible core of the definition of political prisoner under international law and the Ugandan constitution. For those of you who have gone to law school, you would have met the extradition law. You would have been introduced to the Extradition Act during perhaps third year criminal procedure. And at LDC, you also studied some extradition. So under the corpus of extradition law, the political offense exception stands as a global yardstick for defending against applications for extradition. Shamim, extradition is what, for instance, the Ugandan state wanted to do against me last year by issuing summons and elevating them to Interpol red alerts so that the judicial systems of any country in which I am can cooperate, can offer what they call mutual legal assistance to another republic like Uganda to present a fugitive back to the country which accuses him of crime. So this used to happen a lot until states agreed an extradition treaty and said, no, there are some offenses that must be accepted, removed, denied. And those offenses are called pure political offenses. So if the case against you is treason, like messages, there is no court in the world that can give an extradition order for your return. That is why Vestige was merely, in vernacular we say, stolen, abducted, and renditioned to Uganda. And then the Ugandan system started to pretend as if it had a pure offense against him. But in international law, treason is called a pure political offense. Sedition, kalebule, okulebula abakungu. Sedition was outlawed in Uganda in the year 2010. Okulebula president to annoy and insult the president and his staff and his government and his ideas and his policies. Okulebula abatuchikirira. Okulebula parliament, the institution, the members, their laws, their policies. Okulebula abalamuzi, to insult and annoy judges. The Uganda courts removed this offense from our books in 2010. The irony is, I am charged with that offense, I'm convicted of that offense, and I'm sentenced to 2 years under that offense. And I'm supposed to be in Lozira with Mr. Otto fighting for me, to remove me, so that the courts which sent me under a non-offense, are being begged to. So there you go. Acts directed at the political order itself are excluded from extradition precisely because they are not crimes in the ordinary sense, but contests over power. Internationally accepted standards reinforced and brought back to Uganda. As Philip once asked me, what is your status, Isaac? And I told Philip, well, you're a lawyer. Debate the question. Am I still audible?
Yes, you are.
Hello?
Yes, you're audible, sir.
Okay. Sorry. So I said, well, my friend, a lawyer, I also have lawyers, international lawyers, and they have told me not to answer that question because I have to look at who I'm answering it to. I must only give it to a judge in their country. Anyway, Amnesty International defines prisoner of conscience as one who has been imprisoned solely for who they are or what they believe without recourse to violence. That's matters of speech offenses, insult laws. You're a victim of an insult law. What you believe, opinions. You have not used any violence. And the closest they say is that there has been a threat to insult. Well, we see the particulars and we say, no, there's no violence. we look for the witnesses. So where are the witnesses? And that's it. And that's why I think in all the cases Mr. Elotu is doing, the state doesn't have witnesses. It's so amnesty. Of course, the amnesty website, Shamim, is where you must go starting today, and how they treat the amnesty political prisoners and how they arrange. I will say something more about this later towards the end. But amnesty has a broader category of political prisoners, which encompasses any case where a political motive colors either the prisoner's conduct or the state's response. A political motive is a contestation over power. Political motive. When I said Abodo is a vagina from Karamoja, Rotten Tomato, who won't change anything for our justice? I was saying, I was attacking the political appointment because she's only a DPP by political appointment. And the tweet was clear. But the tweet made the entire corpus of legal practitioners in Uganda, civic activists in Uganda, they gave it was quite flimsy and disappointingly underwhelming. Those are political statements. They will continue to be made, and they enjoy ironclad protection under the law. The Council of Europe's guidelines. Council of Europe is a little known, a lesser known governmental body. Apart from the EU, the Parliament, the Commission, there's something called the Council of Europe, which issues a number of guidelines that set a baseline for rulemaking across the Eurozone. It says this, that any detention in violation of fundamental guarantees such as freedom of expression, assembly, association, or for purely political reasons qualifies as a political prisoner. The UN Human Rights Committee, which is the agency, the committee of experts appointed by the General Assembly to interpret the International Covenant for Civil and Political Rights and guide state parties in the implementation, but also to monitor state parties in their commitments to the treaty on a periodic basis known as the Universal Periodic Review, which happens in Geneva, for which I would like to invite you, Shamim, next time we are going as the Ugandan Society. You go with me and you see it, and you state the case for Uganda. But you are now a leader in the political party. You are now a leader in the government of Uganda. You are entitled to go and address the UN Human Rights Committee on the question of political prisoners. Look for the day they are receiving submissions, submit yours, and tell your people that you're doing work, you're fighting. It's not only a Lotu's fight. You are legitimately among friends. It interprets, the ICP, as I've said, it has a document called a general comment. When it issues it for the world, after the state parties have approved it, it is issued. It becomes like a chapter in a Bible, or, not a chapter, a book. We look at it as a source of reference of law, what we call soft law, because it's law coming from international customary law. The most important here, of course, general comment number 34 on freedom of expression, and general comment number 35, Mr. Lotu, on liberty and security. Mr. Lotu, I would like you to read general comment number 35. I would like all your staff to read it. Both 34 and 35 are supposed to be baseline instruments. Up the game. Ugandan law is dead. It offers no clear framework of, it will take us nowhere. And here we should celebrate and congratulate the Constitutional Court in the recent case of Alternative Digital for affirming without equivocation in one unanimous judgment that these instruments are binding law on Uganda. Instead of in your lifetime, as you begin your career, the courts are telling you these instruments supersede Uganda law. And Uganda law, if it doesn't match these instruments, is unlawful. That's the judgment that came on March 17th. The fight wasn't in vain. Madam Shamim has said, the bush, the digital bush, the fight of the digital bush wasn't in vain. It has got judges to speak so clearly what was too difficult to achieve 20 years ago in Obo, 24 years ago in Obo. It was hard, it was expensive. It took an appeal to the Supreme Court. And the courts were starting, they couldn't really say clearly whether these things are binding law. They called them lesser level guidelines. But now the court has said they are binding law, they are supreme. And this is a build, it builds on the jurisprudence of Attorney General versus Kavaziguruka, 31st January, where again the Supreme Court unanimously says, yes, the African Commission principles on any point under the Banjul Charter, that's the African Charter of Human People's Rights, and the general comments guidelines, when published and approved and adopted by the General Assembly, they are binding law. Binding law is the word they used. And Mr. Elotu, that is your legacy. To accept no other reference beyond these things. Now, the Human Rights Committee condemns harassment, arrest, imprisonment, detention, what my brother Sava talked about, of individuals for their political opinions as a direct violation of covenant rights. This is a principle, again, like I said, it's reiterated in the March 17th decision, which said publishing not only false news, but also any form of publication should cease to be an offense. So it says, we have accepted as the Constitutional Court of Uganda that Uganda should repeal all laws that criminalize sedition, insult, and publishing false news, and criminal defamation or criminal libel. And the judges offered what we call a mea culpa. We were wrong, we are sorry. In 2009, we got it wrong in the case of Uganda versus, in the case of Joachim Buembo versus Attorney General. But I won't go into principles that deep. The African Commission, our own protector. Shamim, you're now a leader. Go to Banjul and see the African Commission on Human and People's Rights. Elotu, take time, go to Banjul, go to Arusha and see the African Court and build relationships with the African Court judges and staff there. Because Uganda is dead in terms of rule of law, but it's not the end of what is to be done. You must externalize the struggle. You are the GenZs, it's your time. Do what we didn't do. We didn't go to Arusha, yet it's so near. We didn't go to Banjul, we didn't go to Geneva. We were lied to by our teachers that those things are not law. They were lying. They didn't know. Or maybe they were so enthusiastic to make this constitution, law, to make Ugandan judicial system a justice system. They had hope, but all those hopes have been crushed. So what do we fall back on? Do we believe it's like entering a room where people have already eaten? Shamim, have you attended the Mauledi before? Unfortunately, I can't hear your response.
She says,
you give her the microphone.
She says she has. There's a microphone before you there.
Give her the microphone. Don't mansplain her.
Activate it with the button before you. Yeah. Can you speak, please?
Yes,
don't mansplain her.
She can speak now.
Yes. How does a mouth explain how plates would look like when people have already eaten at a Mauledi and they have just gone to pray? They have gone to enter the mosque. What does it look like?
It's a complete mess, but the plates are almost clean, but at the same time dirty.
And their bones.
Yeah.
They have eaten all their meat, but their bones. That's what Uganda law looks like. Put her back on the picture. I want to see. This must be as interactive as possible. I'm jazzing with GenZs. Right?
Yes, Mr. President.
You are again mansplaining. I want to hear Shamim's response.
Yes, please.
Yeah, that is what is the operating environment for justice in Uganda. The Philip Karugavas who presented earlier, they talked to real judges and they got judgments like Uganda Law Society versus Attorney General, Constitutional Petition number 2, the one he talked about. We are trying to build on that, and we are being locked out of the court by judges. Do you understand me now, dear?
Yes.
Yeah, the judges are saying the food is over. There's no more food to eat. It's over. Eating time was
Done.
before COVID. There's a new post-COVID era. You understand?
Yes.
And so you must wake up to this reality. Mr. Lotu, put Mr. Lotu on.
On the microphone before you.
And on video as well. Mr. Lotu, are you there?
Yes, I'm here. I'm here.
Are you understanding the metaphors I'm using?
Yes, I do. I truly do.
You have to accept the new normal. Just as much as you put energy in going to Butambala, Koboko, Karamoja, all that energy, as you do it, find an app, get a way where you inform the Human Rights Committee immediately. File every charge with the Human Rights Committee exactly. Can you understand that, Mr. Lotu? All right? Write a letter to the Human Rights Committee that from today onwards, I will be faxing a charge so that you put it on the Uganda file. We didn't do these things, we're not told. But this is how other countries where they have been having serious juntas. Do you know Myanmar? We have met lawyers for Myanmar. And you say, but do you practice any law there? And they say, yeah, we report to the Human Rights what? Committee. Then I say, repeat that. Yeah, we report to the Human Rights Committee. And then we leave the UN General Assembly to fight for us. You get me, Mr. Lotu? This thing was told to me by a group of activists we met in Marrakesh. In passing, I never interrogated what it meant. But later on, when I met my colleagues, the Jesus, the person who founded the office you have, Mr. Wameli, I told them that Uganda law cannot deliver results. We have reached a kill or sack. Can you put Mr. Lotu on, please, video? I'm talking to Lotu now. He's my guest. So this is how I conduct counsel. It's intimate. Distance does not operate as a barrier. So we had this discussion with the founder of your office, the deceased Wameli. And I met him in Boston a few weeks before he passed on. And he told me, Isaac, forgive me. Forgive me. I thought you're just too much. I thought you were too hard on the judiciary. I thought you were too hard on us. But now that I am entirely in my last days, I realize that you were right in saying, memento mori. Do you know what that means a lot? Hello?
No, I'm getting you. I'm getting you.
Yes. Do you know what memento mori means?
I have not yet addressed my mind to that.
Yeah, memento mori is a creed that comes from the time of the Roman Empire. Before Roman youth went out to war, there was a ceremony where they passed through a pit stop, like a pit stop, like in football. Arena. They are going to pour on them water and do on them rituals so that they go to war tomorrow. Now, there is a walk, a mile walk, where they would shout at them, memento mori, memento mori. Remember you must die. Remember you must die. This is your last exhibition. You know, be proud. You are going to die. But how must you die? Of course, it's with courage. So you know the haka from New Zealand. You know the haka? The cultural dance from the rugby team of All Blacks. Yes, that's a memento mori, you know, in their own way. They are telling the opponent that for you have come to have a game. For us, we have come to die. We have not come to play. We have come to die. We have come to die. So have the same conception. But then what does it mean from a legal perspective? That did you, as you expired, did you shoot all the bullets you had, or you could have shot? We had that discussion, and Wameli told me, Isaac, you're right. There were so many bullets you would have shot at great cost, at lesser cost. Look at my body now. I get you, and I don't say this lightly, but I do recognize the tradition you're coming into. I too was in your position. I was deputy legal secretary for the FDC for a very brief time. My predecessors, Galisonga, now new honorable Mudi Abole, Mudi Nasa Mudi. We've been in this situation, and so we know what doesn't work anymore, and you should take that into consideration. We are here to support you, not to criticize you. So here in Uganda, the African Commission has documents which, as you have heard in Kavazgiruka, they said these are binding law. It's principles on arrest, pre-trial detention, which is your concern, and prisons similarly rejects the use of state machinery to suppress legitimate political activity. So there's a body of law around the condition of political prisoners. Here, the junta's police regime mocks all these standards while trampling upon our supreme law. You could get the impression that these standards are on international law, but they're also in our Article 143, our Article 43, Article 2A. Have we had that conversation, Brother Eloto? Have you had a chance to look at Article 43, Article 2A? Can the Constitution be given to Mr. Eloto? If you're familiar with it, you can vocalize it in the microphone, so I know we're on the same page. If not, ask for the Constitution. They have it. No, Secretariat must bring you the Constitution. You're our guest. Don't do labor. Today you are our guest. But I cannot stop you from habits. Article 43 2A, see what it says. Please read it. Jerua, if you have the Constitution, you may read. And I think we should start to have the Constitution on the podium. Yes, when holding Rnblive. Yes, sir.
Public interest and
Jonathan?
Public interest under this article shall not permit political persecution.
Yes. The question we've been discussing with my brother Philip and others is that how come in 30 years we haven't tested what was meant by putting that limitation on the state? That the state shall not enter into the terrain of political persecution. Where is the judgment saying that at this point the state had entered political persecution? Do you know any, my brother?
No, none.
No. Okay, I could offer two. We only know of two. The first one is called Constitutional Petition number 7 of 2007. The case in which a lawyer his head was squashed, and a lawyer was beaten the full viewing of the Deputy Chief Justice, and his head had blood, and in fact the lawyer died. He never recovered from the sickness. May we also take a minute of silence to remember him, Chiemba Mutale. So in the infamous Black Mamba trial, crises, because there were two. This time, again, people were given bail, and the Black Mamba descended on the High Court and said, Tebajja genda, we shall pick them and take them to different prisons in Uganda. And of course, Mutale he had finished getting bail for the clients, and now he was protecting people from being abducted. And these people were pulling them, and the safest place they thought was the chambers of the Deputy Chief Justice, because she sits at the High Court there. And she allowed them to come in. These guys didn't care. They beat them up from there. Did you know this aspect of your history, Jonathan?
Yes, I know this.
Yes, so it's the Ugandan Society and others filed cases about it, of course. But there's that one is by Dr. Kizza Besigye himself and his co-accused, 9 or 10 of them. And the court said that the treason, no further trial of Besigye on a treason charge in any court in Uganda would look like justice. So they issued a permanent injunction for charging Besigye and prosecuting him with treason. So why is Besigye again on treason? And why are we taking it that the government now, which has never given mea culpa for CP7 of 2007, has gotten it right now? Why aren't we saying no? In the last 18 years, since CP7, the government conduct has deteriorated. The government should be denied the right to charge, arrest, prosecute Besigye and others connected with him by the same principle. The other case that comes to mind is called Robert Sekabida. You familiar with it? That one, I think you are. Uganda versus Robert Sekabida. The decision of Justice, I think, Ralph Chan or something, at the High Court before he went to the Supreme Court. Yes, where that case arose from it was a mass incarceration from the so-called Buganda riots crisis of 2009, September 2009. These people were arrested in September 2009, and they brought them for trial in 2021. And so on, the other facts are in there. But the judge accepted an application led by another person who Philip gave credit, Dr. Makubia. Dr. Makubia, I forget the other name because he was my teacher. But okay. Yes, he moved the application because I think he was Attorney General for the Uganda government then, and it was only decent to show solidarity with these activists or these arrests, because the court discovered that some of them were even just enemies of police officers in Manatete. Because they just kept chasing anybody called the youth. It was a mass incarceration. The judge said this can't be the prosecution and stop the charges. So Uganda has that history, colleagues. We shouldn't give up. Now, the other article, of course, is Article 120, Article 5, which anchors the independence of the Director of Public Prosecution, and it forbids the very use of political direction, selective prosecution. But these are the things we see in daily practice. And we are mooting a way of implementing these two articles, focusing as a site of struggle. We focus on Article 43, Sub-Article 2A, and Article 120, Sub-Article 5, as a daily site of struggle for the legal profession. So the Museveni regime has turned our criminal justice system into a conveyor belt, where arrest is unrestricted. Anybody can be arrested at any time, anywhere, and lawyers can do nothing about it. torture follows arrest, fabricated charges, endless remand, selective bail for the connected, and so on. This is not law enforcement. This is lawfare, and this is documented. Our mistake has been to look at these as independent events of law enforcement instead of looking at them collectively. Dean Lubowa Sava was represented by the Ugandan society as an individual, but there are many people suffering the same charge, and no one of us is looking at collective state conduct so that it can be denounced even by a local court as, oh no, we are sorry, we didn't know that when looked at as a whole, it is not law enforcement, it is lawfare, and it's unlawful, and the government must take special steps in terms of Section 15 of the Human Rights Enforcement Act to seize that sort of, fashion of law enforcement through what you call structure orders. You know those things. For us, they didn't teach them to us, we have to teach them to ourselves. But for you, you must be filing for structure interdicts, structure, orders. The government to do this and to show this and to amend this law, so on and so forth. That's what other GenZs are doing with legal skills. And you are sufficiently tooled to do like that. It's just that we have to offer you a new framework of thinking. What is to be done to break this police to prison regime? On the 23rd of January 2026, Mr. Jonathan, you remember, you led us to Magere in a delegation, of course, involving our vice president, who I think I have seen. He has come, the most perpendicular, Honorable Anthony Asimwe. We stood before Mama Barbara Kyagulanyi and made a solemn promise. We made 3. I want to focus on the 3rd one because I think we have delivered partly on 1 and 2. I will focus on 3. The 3rd promise was a national dialogue to lay bare judiciary's role in enforcing repression. Of course, the first one was to file a suit to end the siege, which we did, working with your legal department. The second was to explore opportunities for reporting Ugandan lawbreakers abroad, which we are doing, and we shall soon reveal to the world that we haven't been sitting. So lawbreakers in Uganda, the campaign is over. We have also been cooking. We shall unseal soon a promise we made to Mama Kyagulanyi. So the 3rd one is the national dialogue, so that we can receive people's views and comments about how the judiciary and the legal profession have participated, wittingly or unwittingly, in enforcing repression. We've never had such a dialogue, ever. That dialogue must convene urgently and unapologetically to examine how the courts have failed to develop and to implement any meaningful anti-political persecution jurisprudence. Please give me back my 2 guests, because this was the purpose of inviting them.
Mr. President.
Give me the guests again.
The guests have been excused. They said they had other commitments differently.
No, you shouldn't have done that. You should have told me then, not now. You must learn protocol.
My apologies, Mr.
But
President.
anyway, no, it's okay. It's okay. It's okay. Put yourself back. Put yourself back. The essence of this speech and this exercise is to show you where we fail. Are you getting me? In fact, I'm pleased that they have gone, because this is how the resistance breaks. You follow, Jurua?
Yes, Mr.
This
President.
is how the resistance breaks. They have gone to attend to what they consider essential, and indeed it must be. They have gone to attend to what we call bones, blood, and bread. And there is no room where the resistance lands. The resistance refuses to school itself on how the repression operates. But it's okay, they can go. We have a digital platform. This is an archive. The next generation of Gen Zs, I think they will be called alphas. They will find use in what I have to say next. But I have always insisted that the Gen Zs will not succeed because of scatterbrain, like we see now. This is very important, and we must understand and pick this. So, because the goal was to ask that this dialogue cannot happen when NUP itself, which carries the mantle of leading opposition, doesn't own it. When we, the bar, have to drag them into this dialogue. Are you getting me, Jurua?
Yes.
I could be a millionaire in dollars if I don't use my youthful years dragging Elotu into how to think nationally beyond the one client, but rather thousands of clients per day, per year. I had this battle with his predecessor, Wamel, who wanted to be in every court everywhere, running around like a headless chicken, saying, we are paying Bakutebundi. And I said, no, Wameli, we must sit and use new tools. The government has a cyber unit. In fact, the meeting where I quarreled with Wameli, I had been arrested May 7th. We were in the cyber crime office. And I said, look at these people. They have one branch for arresting all of us who use computers. They monitor us from here. Why don't we have a similar command center? Why don't we turn maybe your law firm? Or we find a space where we say that space is the legal shrine for the resistance. And we develop soaps for it and new thinking. Otherwise, we shall all be left to become like Kato and Kakuru. And when I see Kato and Kakuru doing those things, when I say that, you know, I will say this not to disrespect Rakafuz, but you practicing lawyers who do that stuff, ask yourself the condition of Rakafuz. We are taking care of him as comrades. As the bar, we recognized him. But we must understand that we are responsible for breaking him, for never having said, let us study the condition of practice for Rakafuz exclusively. Put ourselves and stay and never leave a place until we have seen that one man, one farm can't be the clearing house for human rights for a dictatorship. It's just not practical. That person will end up in a vegetative state at some point. I saw it with Rakafuzi, I saw it with Wameri, and I told him, all my colleagues who I was practicing around, that this thing is going to eat us, all of us. So me, I'm stopping to practice law of that kind. I'm going to remove myself. You get me, Jirua?
Yes, sir.
You can. You're still young. You still like to talk to the magistrates. These are the principles. You still like to go back. I mean, I did that stuff, and I know where it ends.
Yes, please.
I know where it ends. I know where a lot will end if he doesn't think in the new format. I know. I tell him, Uwameli died at 43. He died at 43 in a vegetative state because Nup sucked all energy and life out of him in one election. One election. So I hope you understand. So it's good that they go. For us, we should have this conversation. The life of others, to stop others. So we promised Mama that we will not be like others and show her that we are doing work. We are the national bar. Our response is going to be national. We are not going to fight for who tweeted what picture, who got what order. We are going to convene a dialogue to examine how the courts have failed to develop and implement any meaningful anti-political persecution jurisprudence. Anti-political persecution jurisprudence. We need one case that can give results for all. I can give you an example. In Uganda, you couldn't get bail when charged with a capital offense, except if you paid the DPP to give you a certificate of no objection until Besigye returned from exile and needed to go to the campaign. So the government lawyers had this impression that if Besigye returns, he must find that he is charged with treason and rape. That will solve the problem. That's the advice they gave the president because it was ironclad. That was the law. Charge him with these things. There is no court which can give him bail. He is not of old age. He is not suffering a condition which can't be treated in Luzira. And then he doesn't have the DPP certificate of no objection. Where will he get it? So without these three things, you could never get bail. That was the law. Ancestors had followed it. They would repeat it. So now we have this situation. Besigye comes. What happened is that Besigye was represented by the whole bar. The whole of Uganda Law Society, East, West, and Brightest, convened somewhere and agreed to fight until this law, and the judiciary did the same thing. So Justice Ogola ultimately wrote that decision called interim bail. The liberty of a man is the source of legitimacy for any judicial system. I'm going to release Besigye to the people and the state, let him do his activities. If he commits other crimes, we shall be here. But for us as a judiciary, he did like Pilato. He said, we washed our hands off it. That's it. The government was angry. It filed a constitutional reference. The case is called DPP. Besigye versus Besigye. It's filed. Can a court do that? Can a court ignore all this law and release Besigye? And of course, the Constitutional Court allowed it. Since then, that was 2005, up to 2020, 2022. That was 17 years. For 17 years, we were all arguing bail. Can I concentrate, Adam? We were all arguing bail. Adam, if you must go, go. You see, digital is not about today. Those who want to go, go. This is about a digital archive. So for 17 years, we all took bail for granted because of a site of struggle called Besigye. The Besigye site of struggle had names, including people like Justice Oscar Kihika, who later on became NRM director. It was an all political parties, all political opinions, just let us fight for liberty of fellow citizens, whether we agree with this politics or not. Now, that's how we got bail. So I look at the elite who's doing politics today, and they do not coordinate with those who don't have NUP views, and they expect to go far. They can't go far. They can't go far. What they take for granted as Uganda law was achieved through a level of thinking, a theory of change that is far more mature and longitudinal. The people who came to fight for Besigye, they were interested in something longitudinal, not the bail of that day. They were not interested in that. You see, you must understand, advocates represented Besigye in 2005 out of self-interest because many clients would come to us to seek bail, and then we have no way of giving them bail unless we can bribe the DPP. So it was in our self-interest as the bar to use the case of high profile to break an obstacle that was preventing us to earn fees on bail. Do you understand?
Yes, I do.
Yes. So it was our self-interest. That's why even Oscar Kiyika, even Yusuf Msibambi, who has since left him, yes, it served our self-interest. We wanted to be able to charge fees for a product we can deliver. And we knew that this time the judiciary, because the international world and their eyes are on them, they will get it right. They will lift this blockade. And then we shall have a new earning what? Earning stream. That's called site of struggle thinking. We don't have site of struggle thinking anymore. We like exhibitionism. We like, you know what I mean by that.
Yes.
They have been fighting. The Lotus have been fighting to remove Mupombiro. Sometimes we keep quiet because our real views will harm them. But fighting to remove Mupombiro, to go and vote, to go and bury, that is not longitudinal thinking. That is emotive and short-term and backward thinking. Longitudinal thinking, you ask the root cause and the net gain. And then allies, you assemble the highest number of allies so that the result is in the best interest of all, including the judiciary, which is itself under captivity. Today we attack the judiciary a lot, but we must start to even be allies, to break it into two, and so on and so forth. But anyways, that's the sort of thinking, storytelling that we want to come out of the national dialogue. Because there are many people like you, Jurua, Erotu, Shamim, you have seen, moving around, doing their very best, but they don't know events that happened 17 years ago. If we don't have memory of just 17 years ago, where are we going? We can't go far. We shall be, around Nansana. Do we think we have finished the world? So we have to forge, we need a national dialogue where we lock down people like Elotu. We lock them down. Even if they tell them that somebody has been arrested, they can't go because they are locked down. We have locked what we call in GenZ speak, locked in. We must get Elotu and Shamim and Dambasa and that Kanyu girl of guild president and close them in a room and get the Askari to take the keys and we give them this knowledge by force. Because if they have liberty, if they have their phones, they won't learn. They will think Uganda began with them, and had no existence before them. And they'll continue to make these mistakes. And when we abandon them because we don't want to be of their level, they will think we abandoned the struggle. You follow? And then we shall have intergenerational conflicts. Yet we could have intergenerational harmony in the struggle. So this mismatch can only be broken in a national truth-telling dialogue. And as you have seen, colleagues from the council who are present, vice president can come and we have the conversation.
Mr.
Vice President, is he around?
No, he's moved out as well.
I saw him. He's moved out, yes. So, unless we have these conversations, we are going to continue doing the bare minimum. We went to court and the judge said she's busy with other cases. We went to court and this and that and that and that, and that's how we shall live out the rest of our years. On paper, we shall have done everything we did. After all this is being done pro bono. No one will want criticism. But in a national dialogue, we should be able to forge modalities for a broad coalition of democracy forces to campaign on selected sites of struggle, such as for the release of every political prisoner. No more slogans and hashtags. We agree that we are going to campaign for the release of every political prisoner. And ultimately, to retake our country from the hands of a geriatric dictatorship that has overstayed its welcome by decades. Unfortunately, most of our colleagues are into these things for objectives which are short-term and personal and transactional. And they don't want that criticism. I think NUP is now suffering a criticism that they eat money from political prisoners. How can we give them a statement of support as the bar when they're invited for a think space like this at the Law Society, they can't complete the thinking? Are you familiar, Juro?
Yes.
So that's something about. I think I wanted the Vice President and any colleagues in council, if they are there, to see why we are not moving far on the dialogue. We cannot convene a dialogue where the most significant beneficiaries of the dialogue are scatterbrained, absent-minded, and difficult to pin down. By the time the dialogue, when we bring in special rapporteurs, for instance, to speak, the room will be empty. The law will be saying, I am going to parliament. The Secretary General of the political party will be saying there is something more important. I was in FDC where they are, and I had to resign because I said there's no point serving in a neck where we can't sit and complete a train of thought consistently by bringing the full weight and intellectualism of everybody in the room. Why are we supposed to succumb to the mediocrity of a few? And we call this a political party. That's why we prefer to be outside of these political parties. Because even simple things like sitting down to think conclusively, definitively, from history, from true history, not speculation, not emotion, from true history, as told to us by those who lived through the critical junctures. You follow?
Yes, please.
They've delivered us. That's the only way we can get deliverance at a broad level. So the dialogue remains a priority for the bar, but it has shortcomings that are played out very quickly. As the Radical New Bar, we have already selected specific sites of struggle to recommend to the GenZ movement. But we cannot recommend them to an absent movement that is not represented, even in our own internal discussions. They won't own them, but for the record, we shall state it. Political prisoners sit at the center of any such program. Political prisoners should be the singular. They should get pride of place in our thinking and dedication as a collective. We should call each other in the morning to say, there's a meeting which are on political prisoners, you have to come. The way we attend vigils and this and that, with their inevitability, we have to deal with this problem that way. We must, and I do know that they do deal with this, of course. I mean, they must attend to new arrests and everything, and so on. But as I conclude, you will notice that the state can keep them busy at that level by
Mr. President, we seem to have lost you.
But I think a lot to say it. Even the prisons that call the bishops who are involved in transactional business. And I think that was the point. He's now not here. But I wanted to tell him, I think it was Dean Lovoa. I wanted to tell him that that very point is what we wanted to say in our keynote speech on the 7th of February 2024 at the opening of the new law year. We want to tell the judiciary that be careful as you remand. Ask yourself, you never ask yourself where people are coming from and where they are going. But there's an economic system where some people are profiting from this. And it has got nothing to do with state repression. It looks like repression that is politically orchestrated, but it's also economically driven. And that would change judges' minds a little. They would then, when you show them this evidence in a conference, like judges conference, they'll probably learn better. But we are still thinking that, we can take each case as it comes. I don't think we shall go far. We must wage a coordinated campaign around selected cases, like the Mwanga Chivumbi treason case at Butambala and the Westj's treason case at Kampala. None of the parties representing those people has approached us as the bar to congregate for them a collective think space around these matters. So they are on their own. Yet these are textbook examples of abuse of process and lawfare designed to criminalize legitimate political contestation. However, the teams representing them, they all go to Butambala every morning, every fortnight, let me say that, every fortnight, to address one magistrate or something, to put we're all asked to put all our eggs in one basket, as though that's how we think. We think differently about a situation. We all solve problems differently, and we should be able to address the things knowing that there is independent thought, but it must also be coordinated. You also just say, you do your things. When we speak like this to some activists in their conversation and spaces, they say, you do you, we shall do us. You do you, you do what you want, don't tell us. And you're like, no, it doesn't work like that. We must meet in a place and then agree how we separate it and divide labor. Because ultimately the problem we are trying to address is united, and so on and so forth. So I want to go to the case which is specific for Nup. Nup, during the time of Wameli, failed to confront the government's attempt to decriminalize wearing the red beret. They took it lightly, and then they end up with having so many political prisoners because the party did not address the source grievance around the EPDF Act in time. Now they have been forced with the issue of unlawful drilling charge. And I don't know how they are managing it. We don't know how they are managing it. But it's a charge which can take everybody, including their leaders, even a lot. They can just pick him up and put him on it, and so on and so forth. And now the so-called Protection of Sovereignty Bill and the latest constitutional amendment gambit to extend the duration of a political term in any of the two political branches. These battles cannot be fought in isolation. They must be prosecuted in cohesion with the national bar under the banner of the Ugandan Law Society. We give compliments to members of our senior bar who participated in the old struggles. We are aggrieved by the silence of members of the senior bar who have refused to participate in new struggles for liberty and freedom of Ugandans. But we shall make no apologies for our executive orders like number 6 of 2006, because in our view, when we scan the environment, the era of political accommodation, polite accommodation, civility, compromise, and accepting corruption is over. We must enforce now Uganda Law Society Executive Order Rnblive number 7 of 2026 through a national boycott of the courts until the judiciary demonstrates that it can deliver justice rather than repression. How do you arrive at a national boycott of the courts? It is something for which you need court users to meet in a national dialogue or even in committees, small committees that will make it possible, because it's their rights that they are going to have to burden by the boycott. We need a boycott, Jirua.
Yes,
we need a boycott.
That's true.
We need a boycott of the courts. But if Erotu and Shamim, the major court users, can't sit at the bar office to discuss the terms of the boycott, shall it be one long month, or can we choose one day every fortnight? Because judges already boycott us, by the way. Do you realize that the judiciary, for them, they have a national, they are always in boycott terms. Do you know if you went to Katakwi today, would you find a magistrate?
No.
No, they will tell you he works Tuesdays and Wednesdays. He has gone to Kampala. Thursdays, he stops at midday. He has gone to Kampala. Come back Tuesday. So the judiciary already did boycott. So we can actually look at the time which court users won't miss. Because after all, even on those days, the substantial number of courts won't be working. Are you getting
Yes.
me? Or we can zone the boycott and say, okay, the people of Katakwi, use the days when the magistrate isn't there to say that's your boycott. So that when the magistrate comes, you know, because the magistrate lies to the government that he or she is there, yet she's not there. So use their weakness against them. These are things we need to discuss in a group setting like this, so that we can build a national moment, change the behavior of repression through the judiciary. I would like to say that if we are not thinking longitudinally, we make a very fatal mistake to ensure that the absence of the legal profession doesn't affect it. They have said this in two statements of the Chief Justice, the former Chief Justice and the current Chief Justice and the Attorney General. This is how they feel. This, what will a lawyer change? We want to file. What will you change? What you want to file is just going to disturb us. Legal arguments no longer work. All decisions in the judiciary are done through State House, especially around criminal law. So judges, you know, they take their orders from RDCs, DPCs, security, lawyer, but so we keep ignoring. We talk about these things in WhatsApp groups and everything, but we never bring these things into a concerted discussion that will arrive at results. We have to agree that how do we let the regime feel the absence of the legal profession? Because it has taken our absence for granted for some time now. That's the former position, and you all know it. Mr. Roto has gone. This part is meant for him, but I will put in the record. First level legal aid, which he does, rapid response, is good. I did it also, but it is not great. We salute lawyers like NUP's head legal affairs, Jonathan Elotu, for his tenacious victories on bail and habeas corpus applications. Real wins extracted from a hostile system. But as colleagues who have been there and done that, we tell him in this moment that we must level up. The radical new birth demands an aggressive counterattack against the repression conducted by government lawyers. And by government lawyers, I mean government lawyers, lawyers employed by government, whether they're in the judiciary, in the DPP's office, in departments, in ministries. They are doing all sorts of things. Or they're ignoring their duties in those offices and just saying that nothing can be done. That's the real problem. New tactics are required. I've suggested before, you've heard me, before to him in private, and today I want to go on record, that we need data-driven litigation to expose and dismantle the architecture of mass incarceration. Let me stop here and ask, is there any, you know what, NUP was asked to give us their data on the problem of political prisoners. Did they bring the final report or not?
No, they haven't yet.
And we've been asking since January, because it was supposed to be a part of our election observer report. They brought Kato and Kakuru to lay apologies, right?
Yes.
And then they said 2 weeks. 2 weeks has become How many months now? 3 months. February, March, and April. We are about to finish April. Yet with the data, even me, who is right now in the sitting where I am, with lawyers who are close to international systems, we can design litigation of a special nature, pound for pound, and we can blow the state out of the water. Are you following?
Yes, please.
But we need the data. We need the data. One charge sheet is of no significance to the Universal Periodic Review System. You can't blame the architecture. You can only talk about the person. We are stuck in the person. We are stuck in the person. Our hashtags are justice for Mufumbiro, justice for Mufumbiro. And the state likes that because you're not attacking the architecture of mass incarceration. Why? Because Erotu is still operating with the soaps of the dead Wameli. Wameli, the thing Erotu is doing killed Wameli. They killed Wameli. And they will kill more. Until we understand that we must tackle this problem at a systemic level. I have suggested before that we should not get people bail so that the prisons overfill. And then the state, which says there are no political prisoners, is forced to concede that the word that they are political prisoners and release them for its own survival. Other countries have done those things before. And they just say, courts are the ones arresting. Then the courts themselves will say, no more remands, shorter remands. They will sit themselves in a conference like this. Already it's happening anyway because we can't represent everyone. That's the point. Our tactics, we can't represent everyone. There is a discrimination. We are discriminating in who we represent. You know that you go to prison daily. Yes, so we have to do data-driven litigation, expose and dismantle the architecture of mass incarceration. That is a site of struggle. We have to do systematic trial monitoring to document every procedural abuse. Case in point, Computer Misuse Act. Yes, there's some element of capture of data systematically there because every Computer Misuse Act offense makes news. So we tend to have a sense of who has been arrested. But how about those who are, abducted, not arrested, and not brought into the formal system? But even for those who are in the formal system, we have no basic archive. I've always argued with my friends at Angola, they used to not like me for many things, but all I was saying is, we need to make an archive jointly. Look at it and then bring all our thinking. We don't have to like each other. Data doesn't care about feelings. Jurua, have you gotten me? Can you repeat that?
Data doesn't care about feelings.
Feelings, yes. Yes, the charge sheet doesn't care about the feelings of the lawyer handling it. That's it. And that's why in the judiciary, they encourage calling us A1 and A2, so that the judges get no feelings. You follow?
Yes, please.
That's how they maintain mental health. We must use the same tactics in reference, in response. So at the ULS, I have stated before, right from the first RNB, I believe, that we are structurally decapacitated by lacking a high-profile case unit. A legal aid and pro bono department or mechanism is not the same thing as a high-profile case unit, because high-profile case unit involves level of escalation. We pick a matter from the legal aid and pro bono unit, and then we escalate it into the high-profile case unit. The tactics of which are different. We are decapacitating that, and we must resolve that issue. Those of you who are in secretariat, as you plan, as you budget, you must remember that for us to be meaningful going forward, we lack a department that rises to the tempo of the systemic problem, and that's called a high-profile case unit. Of course, a high-profile case unit must be complemented by trial monitoring system. So we are further decapacitated that we don't have a trial monitoring unit which monitors trials and flags them according to a coded system like the one for traffic lights, red, yellow, green, pink, or something. You know, you can use the colors of the rainbow, give degrees. We are monitoring. Does a case move from 1 degree to another, necessitate the ULS to get involved through either its pro bono department or high-profile case unit. This is the kind of long-term thinking we need. We are also going to start with a dedicated committee to help us check lawfare by prosecutors and magistrates. And I'm glad to say that senior advocate Karugaba has accepted to convene and to lead this committee. As the first step to all the things I've said above, pettiness must end. We must fight to win. So, colleagues, brothers, sisters, the way forward is clear. We must sensitize these Gen Zs who can sit in one place and think. But to be a Gen Z, they have said that they are characterized by one characteristic. Do you know it?
Yes.
Yeah. Which is that? Apart from the range, of course, one human behavior that they all share.
Pettiness?
No, short attention span.
Short attention
They
span.
are born in the scroll. They are born in the scroll in the time of scrolling, swiping, clicking, and moving on. Okay.
Yes.
They were born. They came into adulthood with a thing called a smartphone. Too much gadgetry. It was bombarded to them early, so they cannot read a book and they can't complete a conversation like this one. They cannot distinguish between Jurua and Semakade. They cannot understand that Semakade is in exile. When he offers himself available to speak to you, you cancel all other programs and complete, because you won't get that experience anywhere, ever. That's Gen Z's for you. So if Gen Zs want to organize, they must understand how the opposition, how the states, the system, how power, because power knows a lot about Gen Zs. It knows them for things like, and therefore it can easily distract them. Like Gaba, it can distract them, give them distractions, they will buy it. Of course, not to say that earlier generations couldn't buy distractions, but earlier generations at least organized in manners that are a little more grounded. Gen Zs will struggle with having their feet on the ground for a period of time. So, especially our young women who must suffer greater conditions of poverty and repression than others. But the point is that Gen Zs must be sensitized to drop the novelty mindset. This notion that everything is new, it is happening to them, it is the first time these things have happened. That mindset that treats every protest as virgin territory, that their outrage is novel. No. And some of us are tired of it, contemptuous of it, and we have become cynical, and we have retreated from that. From that, even power itself. During the walk to, what's it called, march to Parliament?
Yes, march to
During
Parliament.
march to Parliament, yes, they used to tweet march to Parliament, and I would tweet march to nowhere. And they would attack me, abuse me, but I felt that was my contribution to their resilience. I would say, this is march to nowhere. Then I tweeted, there's a picture where I tweeted the Burkina Faso Parliament burning, and I said, that is marching to Parliament. In Burkina Faso in 2014, the Gen Z is there. They didn't just march to Parliament. They knew what marching to Parliament meant. that it must not remain standing. The Kenyan GenZs also had to ask themselves that question. They knew that this thing won't end until we steal it is called the mess. You saw the American January 6ers.
Yes.
They knew that we have gone to Capitol Hill. It will not be over until the fat lady sings. It will not be over. So there's no novelty in these things. If GenZs want a site of struggle, they must define a site of struggle clearly, without thinking that it's novel. History, it's power. We must tell our GenZs. Uganda is not a one-party state or one-party street, as Jonathan thought. No, Uganda is a nation with a living memory of resistance. Ugandans are not idle or forgotten, no. I will speak to that, of course, another time. But we have to tell our GenZs to find authentic stories of fellow GenZs in their lifetime. For instance, the Bangladesh GenZ president, the Sri Lanka GenZ president, the Kenyan GenZ president, the Burkina Faso GenZ president. And they must know these stories. And when they come to places like this, they must be able to talk fluently about those things, what they've learned, and then they find their own Ugandan GenZ movement and define its objectives clearly and choose their sites of struggle. Some of the battles they are fighting are not theirs. When a generation has refused, whenever a generation has refused to accept the old order, the latter has fallen. We can do the same. But sometimes I see contradiction in our GenZs. I can use the example of the election they have just gone through. I wanted to ask Shamim to give us that experience, whether the election should have been boycotted. How does she square her participation in that election against the cause for boycott? You know, it would be nice to hear that. Lastly, I want to say that, well, Shamim is a former guild president, but our invitation was for the current guild president. I didn't understand fully the reasons for absence, but like you said, they are GenZs, and she should be very careful, whatever the reasons for absence were, because in my view, that is the baseline of reference we shall all forever have. The eyes of the nation are upon her. They are upon you, Miss Gracious Kadondi. When you are invited by the National Bar Association to come and address it, shortly, the day after you're swearing in, and then there's something more important for you to do, then you clearly don't know the time you're living in. Will you be a national leader, or will you be merely a prefect and a pet of the vice chancellor? Did you choose to attend a mere activity of the university, a regular activity for which there are going to be plenty? It won't be plenty times that the National Bar Association will invite you to address its 7,000 members. It won't be plenty times that they invite you on the day of they invite you to bring the after party of your swearing in to the National Bar Association so that they can be a part of it. It won't be a plenty time. And it has not been done before. No other guild president in 92 years has had that honor. That honor was given to only you, and we have received our answer. Where are you today when the prisons swell with your generation's best and brightest? We wanted to hear your answer to that question. You can give it to us anywhere you are. That's the challenge for you. The Radical New Bar has drawn the line. Political prisoners are the site of struggle. Colleagues at Secretariat, take this seriously in your planning and preparation. The GenZ movement is the force. If we do any work around political prisoners without the GenZs, we shan't achieve anything. We shall achieve regular outcomes. Jirua will be able to get an occasional client like Dean Sava who comes and says, thank you. But you had Sava, Jirua, I'm concluding, you don't have to worry. But you had Sava has told you, thank you for removing me, but there are 3,000.
Yes.
You had that bit?
Yes, I
He's
did,
saying
sir.
something now. And he's saying that, I don't know, was it him who said that? And we a part of that incarceration?
Yes, please.
Do we ever think to, because for them, when they sit there in the jail, they lump us with the system of repression. So you had him. So we need a force. We need a force. As you know, the force won't be senior lawyers. It won't be senior citizens. They had their time. They participated in their sites of struggle, in their critical junctures. They are sitting at home as they should. It's their time. It's the sunset of their years. So they should be observers. We should let them be observers. We should not think to them. They have some wealth, or maybe they don't have a pension. We should not really have grievances and grudges against them. History, they are part of history, and history is always watching what is to be done in the now. I think we must act as I have guided above. The junta's police to prison regime ends where our organized unrelenting resistance begins. Free all political prisoners before you swear in on May 12th. Otherwise, we shall have to retake Uganda using all means in our capacity. Colleagues, the future is ours to seize. We can choose to be spectators or we can be the takers. I thank you for listening to me. Thank you, Jurua.
Thank you, thank you, thank you, thank you, Mr. President. We never seem to get enough of you. We're very grateful for your speech, which of course is always a lesson out of experience. You are one of those people that we shall never get enough of you. While you were at it, we were joined by the treasurer. I dared send you a message just to notify you that the treasurer, the governor of Ugandan Law Society, joined us because the vice president also went for another engagement. I believe he's still within, but he went to meet someone else. But the treasurer is in here. We still have Ronald with us, who was earlier on here. But nonetheless, would like to thank you so much for so many things that you've given to us. And just a few to pick from, you have highlighted the most important has been national dialogue. A national dialogue is very important. I've picked so much from what you said, and I believe everybody has followed. And of course, we still have over 226 followers on X, as well as other platforms that are still listening to you. It doesn't matter, because this is a hybrid session that is going to be kept and restored and stored for posterity. Mr. President, you have highlighted so many issues. I can pick out one or two of them. You have spoken into the systematic trial monitoring, which is very important because, as you said, data doesn't have or care about feelings. And you've also highlighted about the high-profile case unit that I'm very sure you recently established. It only did not take the energy that you had asked of it, but yes, you have repeated and reiterated it. You have told us that Mr. Philip Karugaba, amongst other senior lawyers, have offered themselves and their services.
I can intervene a little.
Yes.
A little.
Yes, please.
You don't have to worry. Ideas don't have to flower the day they receive confession.
Yes, please.
Okay?
Yes, please.
Yes, but it's important that those who give time to thinking honor their current and future generations by confessing these ideas so that they don't die with them. For us, we have put the idea at the bar.
Yes, please.
Our CEO has understood it. I think we gave her the full concept. Yes, if and when the conditions are right, they won't be starting from zero. I think you're right in saying that we established it because the paperwork, the articulation is done. And what else? It's like an act of parliament. All right?
Yes, please.
It exists. As to whether or not it has received full implementation, that will be a matter of government priorities. But at least government won't be starting from nowhere. It will pick up the the modalities that lacked funding, then lacked resource, lacked headship, and it moves. Continue, please.
Yeah, thank you. You have also spoken about that boycott of the courts of law, especially to show solidarity among us, all the lawyers, because at the end of the day, as you said before, the two topics to do with today's sessions were to do with encouraging lawyers, but also very interestingly, asking the Gen Zs to lock in the local, in the Gen Z language. It's about time to lock in and seek the counsel and guidance and wisdom from the lawyers and the public senior public citizens that have been there before them. Otherwise, the national dialogue, which is needed to guide the nation about how to go about these issues, other than how it was done by you and the previous lawyers who served back in the day over 10 to 15 years ago, for which there has not been any positive or tangible effect to end the persecution and the political persecution of the political prisoners, for which there needs to be a radical change, and getting it will require that the Gen Zs who have a short attention span and attitude ought to listen in, lock in, and look further into the bigger picture. You have likened the Ugandan situation.
In fact, I can intervene a little.
Yes.
During March to Parliament,
yes,
I used to write threads to guide the Gen Zs, because it was the Gen Z movement, right?
Yes, it was.
It was their thing. And so they had thought that the only support they should get is way. We all go.
Yes.
But some of us, like I said, we were telling them that no, we can't support you to all go, because we don't know what you're going to do at Parliament when you go.
Yes.
So you so what? So what? You're saying so what? Answer the so what. Then when the so what is cleared, you'll have us, all of us. Otherwise, it's an idea for you. I do remember they said, Isaac, they put me on a space, and they said, what do you want us to do? Really? Because you're saying this, and then you're saying that, and then you're saying this. So, for instance, I had said that you should go, but you should know that we don't have enough legal resources to get all of you bail. You should go, but you should know that you must serve some time, perhaps 6 months, all up to 2 years. If you're ready, you go. Those are the people who we want to go with. So, okay, but the point I intervened was to say the words, "Put down your phone." That's the answer I gave them. They said one thing which we should do. I told them,
Mr. President, we seem to have lost your signal. IT?
It's put down your phone.
Okay.
Reflect. Oh, am I back?
Is he back? Please proceed. We had lost a little of your signal.
I was saying that, okay. They asked me for a singular recommendation, and I told them, put down your phone. You don't have to do it every day. You can choose a day. That during this day, we Gen Zs put down our phones and, for instance, read books. All right? Listen to those who have stories about critical junctures in the development of democracies, the development of whatever it is you're choosing to develop. You listen, you learn, you unlearn, but with the phones put down. Because if you pick up the phones, you have already weakened yourselves. You're losing. Because by definition, to be a Gen Z is to be a victim of too much bombardment of information through the phone. Yeah, continue.
Yes, thank you so much. I also note that you have cited the lack of coordination among us, those that are leading in the parties, which of course is supposed to have been the foundation of unity, because we are actually operating against a state that does not recognize dissent, which of course, speaking into the political prisoners topic, is supposed to mean that you need a a comprehensive, knitted together arrangement amongst those that are being oppressed in order to make the numbers bigger, of course, because the NRM has the majority in parliament, and that, of course, we have seen has had quite critical effects on what has transpired in as far as the laws are concerned. You also, of course, cited the Mufumbiro fight, which we all appreciate and sympathize with, but it is just one of so many, and it's really a drop in the ocean and doesn't speak into the bigger picture for us to get the answers that we are looking for. You've asked us, of course, as well to avoid scatter brains.
But while you're there and you're young and
Yes.
it's about information, because I have to tell you this, to most Gen Zs, they were, not just Gen Zs, even us, we were fooled. There's a notion you get that the South African anti-apartheid struggle was about fighting for Mandela. Do you get me, Jurua?
Yes, please.
Can you put the camera on Jurua, not myself? I have no value in seeing myself here.
Yes, please.
Yes. So when you go, what do you think? How do you think they fought apartheid? Those were organizing. Did you really think that they spent out all their time fighting for Mandela? But Hollywood and those who were anti-ANC designed a propaganda war to stop similar movements by making videos and writing books to tell us that this is, they wrote history for us so that it shall be wrong history and we shall never know how they fought apartheid. You follow?
Yes.
So, yes. So most young people are likely to think that we should be fighting for Mufumbiro. We should be fighting for Mufumbiro. That methodology is out of, we call it deprogramming, brainwashing. And it comes from brainwashing that was thrown at to ensure that there's never a movement like an anti-apartheid movement within the black people. These things were done. If you read the quarrels between Malcolm X and MLK, that's what it was. MLK was warning black people, black power, that the popularity of MLK is not natural. It is artificially driven by white power. And white power is not being kind to us because it is generous by nature. No, they have chosen between the two streams of thought blacks have, non-violence and by all means necessary. And they said, let us give this guy a fighting chance to destroy this guy. This theory, this idea, if blacks took up this route, it will be finished. So they put power. They met at a hotel called the Ritz-Carlton Hotel, which is owned by the Kennedys, to give them money to organize the 1 million march, so that MLK can get way ahead of Malcolm X, you know. But this is something important. How do we deconstruct critical junctures? What happened? What was beyond what happened? And then we build a struggle today. So this notion that if we ever get bail from Mufumbiro, would that have been the struggle?
No. Not in itself.
But it can satisfy the ego of lawyers doing this work because they are brainwashed by the movies they watched about Mandela. And they think that was truth. That was fiction. Sarafina was fiction. Everything you had was fiction. Reality is different, and we must start to live in reality. I am privileged to have served and lived in a law firm called the Legal Resources Center in Johannesburg, Bram Fisher Towers, which was the farm where it was the shrine. It wasn't even a farm. They didn't even hate the word farm. It was the shrine in which lawyers who came from all over the world used to meet during the Rivonia trials. Most of them came from, like, the one who was my mentor was Sir George Bezos, a Greek. The firm is well known for Sir Sidney Kentridge, who was a British lawyer traveling, to come and do this work. The building is in the honor of Bram Fisher, who was a white South African, and so on and so forth. But inside that firm, in its library, in its archives, I read the reality of how lawyers organized around Rivonia. They call it the Rivonia Circle. The Rivonia Circle. The trajectory of life would have been different without the Rivonia Circle. Where is our Rivonia Circle in Uganda today? We, the Radical New Bar, have told the opposition we are no longer neutral. We have thrown in our lot with you. Have they thrown in their lot with us, Jirua?
No.
Thank you. Please continue with your summary.
Yes, yes. You also really spoke into one thing that is eating us, which is intergenerational conflict, instead, of course, of looking towards intergenerational harmony, which is supposed to bring the elders towards the Gen Zs, because the Gen Zs need that mentorship, because without it, they're always on their phones and scrolling and cannot even give it a day to read something. So the need for that fusion between the elders and the Gen Zs will also help into speaking to the progress that can be registered. But again, of course, like you said, political parties also have that role, because of the nature of their formation and the structures that are supposed to be national, helps to reach down to the lowest of individuals in the farthest of areas: Moroto, Kotido, Arua, Yumbe, Kabale, Kisoro, and Rakai. For that matter, political parties are supposed to be thinking conclusively and comprehensively in order to make it a point that their outreach is of effect. However, you have also underscored the importance of political prisoners that sit at the center of these discussions. It is useless to have discussions about political prisoners without either them or discussing the root cause of why such situations come alive. You've, of course, also identified with the different situations across the globe, picking examples and situations and incidents coming from Bangladesh, Burkina Faso, Kenya, Sri Lanka, and of course, Capitol Hill on the 6th January 2024, in which it was all over social media at what it means to make a move, a bold attack and a bold move, so as to end the walk to parliament, as opposed to what happened for us this side, where, well, it wasn't a complete exercise, because we ended up...
Actually, let me tell you.
Yes.
Let me tell you what happened.
Yes, please.
In 2023 and 2023? Yes, 2023.
Yes.
What happened is that the people who participated in March to Parliament, most of them were influencers, and they wanted to the buzz. You can see it in the aftermath, where those who went to prison were advertising their prison numbers like trophies. Do you remember that scenario?
Yes, indeed.
Makana, so and so, the prison number is. And in that moment is when I realized that we have a big problem. Because it's called catharsis. Do you know catharsis? It's a condition I first came upon, explained by Frantz Fanon in his books, that among the oppressed, they can give up on the struggle and then they focus on only catharsis. And so we can be around people thinking we are fighting for the same things, yet Girua's concerns are cathartic. Can you define cathartic by your phone? And really, that's the tragedy of the Gen Z. So the Gen Z must be sensitized to avoid the trap of catharsis and maintain focus.
Cathartic refers to something that provides emotional release or cleansing, especially after strong emotions like anger, grief, frustration, or stress. In simple terms, it's an experience that helps you release pent-up feelings and feel relieved afterward.
Likes, retweets, and comments and going viral. You can continue.
Yes, while you were at that, you also emphasized the importance of the notion of political prisoners being at the single soul of the struggle. Like you said before, you continue to show the importance, and that the judiciary, of course, should also be wary of political prisoners, because once a coordinated campaign against selective justice is launched, there will be nowhere else to look apart from humble themselves, because of course, the different scenarios, gauging from aspects and issues that concern.
I can help you.
Yes, yes.
Your summary is good.
Thank you.
It is, however, not a synthesis.
Thank you.
They are skulls.
Yes.
They are skulls. It's called scalp.
Skulls.
It's called scalp.
Scalp, yes.
Huh? Yes. If they don't join the struggle against political prisoners, and we win this without them, where do you think they will be? The prize, the trophy, the victor's justice will be the scalp of the magistrate Ayansiba. Are you getting me, Jirua?
Yes, I do.
Yes. If the people win by their own means this journey without the jurisprudential force, jurisprudential morality of the judiciary then will have to run, judges will have to run into exile. To have been a judge in Uganda under the appointment of Museveni will mean exile. The day Museveni dies, anybody holding judicial office will have to run. They will have to run. Their bedrooms, their children will be ours to rape and kill. I'm telling you, judges must join this battle now. They must be the ones to lead it through jurisprudence, through the work they do. Otherwise, they will leave people to win a people's revolution, and it ends in their bedrooms. You can continue.
Yeah.
I want you to summarize with your own synthesis.
Yes, indeed.
If you have no synthesis, you haven't understood anything we have said today. My speech was in decorum, but you must understand it in doctrine.
Yes.
Okay? Without decorum, be free to interpret me the way you want, like you read a novel. Interpret it the way you want, the way you can, in your own tongue. Thank you.
Yes, thank you so much, Mr. President. You calling for the continued collective think space to handle such issues. You identified with the matter that we are handling, or rather that is ongoing in Butambala, in which, of course, the Ugandan Law Society also had a hand at some time, and that is against Honorable Chivumbi Mwanga, and also the one against Dr. Kiza Besigye, which, of course, has been ongoing for quite a long time. Those are treason cases, which, of course, does not necessarily have any light at the end of the tunnel from what it looks like. And you are saying we are continuing to isolate ourselves in the fight for a common cause that surely cannot end if we don't bring our efforts together. You have also identified with the...
Before you go further.
Yes.
Before you go further. What I'm saying is that we are in a situation where the lawyers representing Vestige haven't read any literature from the Rivonia trials.
Yes.
And so they can't organize a Rivonia circle. Are you following me?
Yes.
I'm sure they have teams. I'm sure they have groups. But you do realize that the first RNB was a union.
Yes.
Of Vestige defense lawyers and the ULS.
Yes, please.
To agree on a site of struggle.
Yes.
Formally, we exchanged the memoranda here.
Yes.
The way it should be done in full view.
Yes, please.
Lukwago came with a memoranda signed on behalf of. Don't you have it?
Yes.
I'm issuing you here an executive order. Get that record and publish it on our socials today. The petition Lukwago delivered here on January 16th, 2025. And we ask, what happened after? Where is a similar petition to the bar? Before people blame us, because we can't insert ourselves in a matter where there's private counsel.
No.
We can't.
No, we can't.
There you continue.
Yes, you gave flowers as well to the senior bar members who have identified with the struggle, but also didn't give any apologies to those who have not identified with the struggle, which of course is a very big gap, what leaves a lot to be desired, because in any case, senior bar members, in your view, should be at the helm of this struggle because of the fact that they have been here before us, and they should be aware about the predicament that we are facing right now. And if we don't have their blessing, it is something that is very deplorable. You continue to stand by your position and be as radical as you've said, and without them, we can still move, because at the end of the day, if the Rivonia Circle cannot be convened with like-minded people, then it will most likely move on its own until it comes to fruition. Nor are you going to wait and sit back because you haven't been supported by senior bar members and all other stakeholders. You also identified with the aspect, of course, of rapid response, but did not give it all the flowers that is required because it doesn't answer the question. Running up and about dealing with bail and habeas corpus applications is just not going to be sufficient to get the ultimate result that we are looking up to. It's about time to level up and be aggressive in our counter attacks, which is going to be the only way we can walk around this. You have also been very critical in referring us to international instruments, which the Ugandan community doesn't actually think it works because it is alien to us, and yet we all know that time immemorial you have been identifying with international treaties, including, particularly in this session, the Banjul Charter and the General Comments and the Human Rights Committee in Uganda. Of course, as you have identified, it is important for us to appraise ourselves with this kind of information and use it to go down to the wire in as far as the definition, for example, of political prisoners, the spaces that they're supposed to be operating in, and how best to understand it. You began your conversation with the meaning and especially the definition of political prisoners, and realized, or helped us to realize, that this political persecution is only to crush dissent, and therefore it will never be sustainable because dissent is part and parcel of a democracy, and in any case it is even better to receive such kind of dissent in order to have a meaningful communication. You identified with Memento Mori and also identified with Article 43 2, in which we were able to appreciate that public interest shall not permit political persecution, and of course also commiserated with Advocate Chiemba Mutale, who passed away because of persecution and also disagreement with what he had to say before the courts of law. And it was a very reflectory aspect of what we need to appreciate. You also talked into Uganda versus Robert Sekabira that arose.
Maybe for the memory, for the memory of Chimba Mutale.
Yes.
I don't know much. I wasn't there.
Yes.
But in the judiciary was foresighted in its treatment of Constitutional Petition number 7 of 2007, Dr. Kizabes Jante and others versus Attorney General.
Yes.
It reproduced Chimba Mutale's affidavit without editing. It reproduced it on an as is basis, so that future citizens of this country like you will know from Chimba Mutale's own voice, in his own tongue, in his own mind, what happened that day and that affected him, so that people like you who in this line of duty can relate. So I wouldn't like you to commit yourself to the circumstances. I didn't say it was persecution. I didn't say this, but I just told that he was beaten up.
Yes.
In the viewing of the Deputy Chief Justice.
Yes.
To the point of a bleeding skull, and that injury was permanent, and it killed him ahead of a full lifetime he could have lived.
Yes.
So, but the real circumstances are detailed as is in the judgment. The judiciary decided that it was that important.
Yes.
And there's a sentence after it. It says that the government had no response to any of these paragraphs.
Wow.
And so we take them to be true. And after all, they're observed by one of us. So you can go. Yeah.
Wow, that is very...
Yeah, continue.
Yes, that is very deep. And I think, as I said after your first speech, we never get enough of you, because all you set for us is more...
I think I can also suggest that, you see, when we say this, then GenZs have little attention span. We have to spoon feed them. So let us also extract that part of the affidavit and saturate it as it was that page. Page 1, Adam, you can understand page 1 of the case, then the affidavit. What happened? Because lawyers are under attack. Yesterday, our own lawyers were under attack. So let us remind the judiciary that as you are the same army, the same security you used to attack lawyers yesterday, once there was a time it attacked judges. Let that record be made clear, and let us saturate that information. Yes. Thank you.
Yes, Mr. President, you also alluded to the fact that the justice system in Uganda is merely a conveyor belt, which of course leaves it in shambles, and that it is important to launch a law fair where lawyers and the public come together to work against the excesses of especially the judiciary, which are supposed to, according to the Constitution, be independent and ensure separation of powers, which of course we would expect that the judiciary should have been the first at the fore to implement this kind of independent positions. And you also, in summary on what you...
A little before you move on.
Yes.
Before you move on, I would like you to get a dictionary definition of lawfare on your phone. It has a different meaning from how you simply understood it. Yeah, clear it for the record.
Lawfare refers to the use or misuse of legal systems, courts, or legal procedures as a strategy to achieve political, military, or strategic objectives rather than purely to pursue justice. In simple terms,
so what you did,
using the law as a weapon.
Yes, so what you meant to say is anti-lawfare. We, the bar, should launch an anti-lawfare campaign. Have you understood this, Juro?
Yes, Mr. President.
Thank you. And continue.
Most obliged. You have also encouraged for us to explore opportunities for reporting. As you say, these ones now you intertwined with the promises that you made to the president of the National Unity Platform to try as much as possible in that particular scenario for him being in a representative capacity of the political prisoners to report lawbreakers abroad in order to bring it out to the fore that we are here and we are not having it as it looks or is painted by the government out there. It's important for us to identify together, to move together, to hold hands together and make sense of this struggle, because if the Gen Zs are going to fear any of these radical actions, then they are never going to succeed. And of course, you identified with the lawyers who
Alito, again to clarify,
yes,
the essence of Gen Z's understanding universal jurisdiction is to operate from the knowledge that the judicial system in Uganda produces impunity instead of justice. You see, the goal of the judiciary, the role of the judiciary, the role of the courts, that's the first panel. The role of the courts is to issue judgments against government actions that are unlawful. So if justice for you means a declaration that government action was unlawful, you can't get it anywhere else in the world except a court. You get me, Jiro?
Yes, please.
A court of that jurisdiction. So if the courts of that jurisdiction put obstacles, impede you, delay you, frustrate you, even deny you a declaration that government action is unlawful, then what they have served is called impunity. They have given government forgiveness, pardon, encouragement, pat on the back, slap on the wrist. If at all they declare it unlawful, they minimize it. Like what the Supreme Court did after discovering that military tribunals were unconstitutional. They then made orders that I slap on the wrist. Are you getting me, Jura?
Yes, please.
That is evidence that there's no rule of law in Uganda. Gen Zs should be able to interpret legal events to such clarity. Many people ask me, why is it that you celebrated? You know, you went to the waterfall. You gave us the Unidolo dance, Unidolo challenge. And then you turned around and went to war against the man. But that's rule of law. In the space between celebrating and turning around to launch war, we had read the judgment. Are you getting me, Jirua?
Yes, I remember so well.
We are only human.
Yeah.
I may be a lawyer, but I'm only human. As on the day of the judgment,
you had to celebrate.
Euphoria took over.
Yeah.
But when we put down the phone and the drinking was done, the partying was done, you're now alone at 3 a.m. You start reading and say, oh my God, have you seen? You call up your colleagues. Okay? Yes. Colleague, have you reached page this? And you know, wake up, and go to that page. This thing is robbery. This whole thing is treason. We must kill Dolo. You get me?
Yes.
The council tells me, Isaac, okay, quiet a bit, put it in a council paper and prove to us. And you prove. Then they say, that's our position. And our position, you know where it is. It is in the East African Court of what? Of Justice.
Justice.
Okay?
Yes.
But do the Gen Zs know?
Hardly.
Did we go with them to Arusha? Do they even care to know what we are saying in their name, on their behalf at Arusha?
In their interest.
Do those who call themselves lawyers of the Gen Zs care to understand how to unite all these things so that the Gen Zs are the first generation to denounce the Ugandan judicial system as is, and they say we want nothing to do with your impunity system. Tubategedde muli bayaayi. Your thieves, robbers in robes. And some of them should even be judges' children, saying that so that Gen Zs get the point clear, saying, you know, it's my dad, he's a nice guy, but we disagree on the reputation his workplace has.
Yeah.
He's a nice guy, but he works at a bad workplace.
Yeah.
Okay? Those two truths can coexist.
Yeah, we follow you, Mr. President. Mr. President, you also identified with the effect of overly running this project alone and fighting for everyone and being everywhere. Of course, you identified with Advocate Wameli. May his soul continue to rest in peace, and your deep experience you had with him and the conversation you had with him towards his death, which of course is very emotional, but yes, you had that conversation, and it was also an example of what it means to fight these battles on your own and overly being everywhere. The same way our senior advocate Rakafuzi is in the predicament he is in, which has left him in poor health, but also because he has been everywhere overly placed in matters to do with the criminal justice system, which of course is a lesson for the Gen Zs, so that we should learn to work together.
Do Gen Zs celebrate what he did for them?
No.
Do Gen Zs celebrate what he did for them?
No.
There is the case of a guy called Gwanga something, the very first case under the Computer Misuse Act. Let me get it. The very first case, that act came out in 2011. That man looked for me on his own and said, young man, you also do human rights. For us, we've been doing human rights. But this act should be yours. That's why I took up the act, by the way, Jirua. Some trivia here.
Yes.
The young, he caught me as I was a Gen Z also. At the time he caught me. And he said, you, Isaac, let me guide you where. You go and go in that side of the farm. Go and dig there. Are you hearing, Jirua?
Yes.
Hello? Oh. Yes. Had he not guided me, I would not have been equipped to represent Stella Nyanzi. Continue. When I get the name, I will tell you.
Yes, Mr. President.
But you see the mismatch. So Gen Zs need John Rainbow. They don't know that there's John Rainbow who was all the time in the world. Are they at his shrine learning from? Are they cleaning his feet? Okay.
Yes.
Because he can talk. All right?
Yes.
He can talk. Are there Gen Zs? If we went to Rakafuzi's home there, and can you imagine Rakafuzi stays at Makerere in the Gen Z capital? Is there a shrine? Is there, is there crowd control at Rakafuzi's home? Gen Zs want to drink from the fountain of knowledge. Because there has been no movement in recent history, which hasn't had Rakafuzi front, back, and center as the legal fulcrum, legal carburetor.
Yes.
Why do Gen Zs think a lot is enough? Why does a lot think is enough?
Can't be.
Why are you getting this? It's called the novelty mindset.
Yes.
Yes.
Indeed. Yeah, Mr. President, the anti-political prosecution jurisprudence is what you are asking us to look further into, because that will bring a situation of togetherness so that we can have one voice to speak into. And Mr. President, that is, in summary, I've tried my best to capture the notes. It is always an honor to listen in and learn one or two things and unlearn a few things we thought that we knew. I am very sure I have taken so much notes, and I'm going to use
you have done exceedingly well. You have done exceedingly well, Jirua. You have won yourself a salary increment. I can tell you. You've done exceedingly well.
I thank you, Mr. President.
You've done exceedingly well, especially the conclusion you said.
Yes.
An anti-political persecution jurisprudence is the best heritage we can give Gen Zs, but we must work together to build it.
Yes, Mr. President.
And today has shown, maybe that's the only conclusion you have left out, because you find it embarrassing. But it's reality. Data doesn't have feelings.
Mr. President, I mentioned it.
On the day we gave, on the day we were here to give Gen Zs the cheat code. To give them the what?
Cheat code.
The cheat code. The Gen Zs left, even the nominal Gen Zs we invited left.
What a shame. What a shame.
Are you getting me? So,
yeah.
So the very cheat code we gave will be for a different set of Gen Zs. Those who will have the discipline to come to this space on their own.
Yes.
In the year 2030, 2060, to say there was once a man, as they said yesterday in the space, that I spoke from the future.
Yes.
There was once a man who spoke from the future and put the whole cheat code there. These are still the same things we are struggling with.
Yes.
But for me, I know I have taken you through so much, and everything, but memento mori. Memento mori.
Memento
mori. I may not be here even tomorrow. So I will give it to you now, and then I've given you the cheat code, but Gen Zs, from tomorrow, you'll only get insults from me. Komanyoko.
Outer roll. Thank you so much, Mr. President. Like it has been said before, now and forever will be. You're an icon, a champion of rule of law, and you don't miss your words. We take them in stride, and we want to put every effort to understand and follow suit of what you have said. I gather right now it is just for us to take action now, especially after you ask that political prisoners be released before 12 May. Other than that, for the Gen Zs, the most important thing is put your phone down and read books in order to understand what was then and what can be done now in order to salvage the future. Ladies and gentlemen, I have no other words to add to what has been presented in the closing remarks or that speech by the President, who has summarized the sessions of the day 1 and 2, both the right to a fair hearing and the predicament of political prisoners. And it is my singular honor to thank you.
Justice Sanders is around.
Yes.
Justice Sanders, Mr. Kapshavi, he has gone to do court business.
He's in.
Mr. Kapshavi, let me greet him in a special way, if he's still around.
He is in, please.
Yes, Mr. President.
Please put the camera to Mr. Kapshavi. Oh, do you still see me? But I'm grateful, Mr. Kapshavi.
I'm extremely humble too, Mr. President, and we appreciate
that
your words and the directions towards the Gen Z. That's why Kenya is ahead of us. When you look at their groups, their ghetto areas, people are informed and they know the fights they take lead of.
Yes. We met in Kenya, so I know what you're talking about.
Yeah.
I know you know what you're talking about. Sorry, I meant to say.
Yes.
Yes. Mr. Kapshavi, let me face him. I want to thank you for me in a special way.
Thank you.
For paying homage to your radical neighbor, taking out time from your busy schedule. You have so many political prisoners you represent, and so many other categories of prisoners. You see, political prisoners are in a special class, and the fact that you stayed to get it firsthand is not something I take lightly, because this is our life, you know.
True, true.
We can say we like each other and everything, but our ideas have not united. We have not sat down to break kola nut, as Chinua Achebe has said. So I thank you for sharing breaking kola nut with me. You know, kola nut is hard to break. So we keep talking until we manage to break the kola nut, and I can share with you the seed for eating, and you leave me with the oil for drinking. That's the essence. It's like a coconut. So thank you for breaking coconut with me.
Thank you.
This is how it is with my colleagues in council who are next to you. Are there still some around you?
Not now. They're just a room
yeah,
away.
But it should give you comfort that this is how solid and how deep we reflect on the affairs of council and the affairs of on the affairs of the society in council. So by the time you see a statement out, the level of examination given to the subject is this extensive. And for us to see a member of the bar witness this activity, this process firsthand, so that he can testify, is a compliment beyond description. It seems indescribable. I'm also only aware that you're young, you have energy, and
Mr. President, we are losing your signal.
I take some consolation that, I don't know. I take some comfort. Am I back?
Yeah, that's better.
Hello, is it back?
Yes, it's back.
Yeah, I take comfort in knowing that by signposting for you change, by giving you the theory of change, you're a change maker. You are a force multiplier for the practice of law. You know, you still have some more track to run than many. In fact, you have a lot. You are the you are the man in the middle. And I think that's why you stayed. You are the tip of the spear for these ideas. Our part is to midwife them with a certain coherence. If they are coherent and understandable, my job is done. But the implementation is for you.
True.
And I would like to be bothered by you on how they get implemented.
Yeah, you have done.
While you are still here, don't. Yeah, bother us on implementation. You talked about this. I would like to try it. Let's try it. Can you imagine we don't have an anti-political persecution jurisprudence? Up to 70 lawyers go to Tambara to see a plea. Yet the facts are all known to us that between the events and the charging, there was no investigation. It is a mass. One of the conditions, one of the evidence for political persecution is called mass arrests. By the time there's a mass arrest, it means, you know, in the case of Robert Sekabira, Uganda versus Robert Sekabira, Justice Rolf Chan says, as long as it's a mass arrest, you may have taken plea before a magistrate, but before a high court judge, you can't tell me that 24 people killed 2 people. We did a case, in the Nyanzi case, a bottle was thrown at a magistrate while reading the sentence. And so there was pandemonium. The police came, and so the police did a mass arrest. Where was the bottle? So ultimately, the DPP presented a charge sheet saying that these 6 people threw a bottle at a and after plea, I was doing the case with Lukwago, and we agreed that Lukwago, allow me to be a bit radical here. So the government, the prosecutors wanted to punish these people. We call them the FB6. First of all, they charge them with 4 different offenses in 4 different files. So that if you ask for bail on this one, you know, you can't get on the other one. And my brother Lukwago wanted to fall into that trap. I told him, Lukwago, no. Now that we're working together, give me a chance to show you something. Under the law, there's something called Section 86, joinder of charges. So, by splitting charges which should have been joined, there has been a wrong framing of charges. Are you understanding me?
Yes.
Yes.
Yes. So I said, Lukwago, let this person, let her read the charge 1. We do the bail application properly on that charge. Whatever the outcome on it, when they read the next charge, we make a submission under Section 86 and 87. We add it together with this law, and we tell the magistrate that you must now direct the DPP to unite that fight. So even our submission was that this case, I think it's called Article 28, Sub-Article 9. It's called double jeopardy. Most people think double jeopardy is about conviction. But there was a judgment which many lawyers don't know. So again, this is called another example of anti-political persecution jurisprudence. It is called, anyway, we can go with Basajja Balaba. Basajja Balaba versus, I forget it, but the Supreme Court, the Court of Appeal, in the case of Kazinda is the best. In the Court of Appeal, case of Kazinda, Kazinda was charged with issuing so many treasury bills. So they would break them down. They bring a bunch of 80 fake checks. When you finish arguing that one, they then bring another batch, and you begin afresh another batch. So Kazinda said, but isn't this persecution? And he got a judgment in his favor. So they nullified all those trials or something like that. So people don't know these things. I was surprised. So I said, you pigs who have come to show sympathy, because for them they had come there as just FBC lawyers. Are you hearing?
Yes, I'm hearing.
For them, they had come to lie to the clients. For me, I didn't come to lie. These are clients who had been in mind generationally. You know what? I said, you guys, you sit and show sympathy. Leave this case for me. And I said, because the law is too complex, beating it with the magistrate first hand is hard. Let's up chambers. And I first show her that I first bang the table of the prosecutor out of public view. Said this prosecutor is not aware of the Kazinda case. We have received the information that you have split charges. It's unconstitutional. Here, and the magistrate reads and says, yes, is that what you have done? No, it's not good. No, it's not good. What helped me was that because the judge was a chief magistrate of Uganda Road, is the one who had been beaten. So we said, let us first go in chambers and say, you have a duty to show the world that the rest of the magic, because we said, this case should be tried on the crime scene. But if you want to try it on the crime scene, you have to prove impartiality at every stage. You can't break the chain of impartiality at every stage, and it will begin with the charges. If Section 86 and 87 are not respected, you have broken the chain of impartiality. So they are allowed. Nowadays, I see people are representing all these people, charges are split, or what, you know, and you're like, okay, you do what you want, but if you had put us in the Livonia circle, we would have given more ideas that are free, but we can't scream advice from a Southern Cree position. We can't scream advice on Twitter. We keep it to ourselves. These are battle stories at critical junctures. The case of FD6, what happened to them? No one asks. No one comes to us and says, how did you manage the case of FD6? All right.
Yes.
Meanwhile, in that case, the Chief Justice had said that they shall suffer. So it was a high-profile case for them, but we managed to beat it because they realized, the way these guys are prepared for it, they just abandoned the damn thing. They just abandoned it. The thing just died. So it's to be for you to be here to because you have your art, you have your experience.
Yes,
for you to privilege mine is not an honor I take lightly, and I thank you for that. Whatever motivation
Thank
that
you,
has
Mr.
caused you to
President,
that. I thank you. I know it can only be for the better. I know it's because you care. You care much more than just transactions. Thank you.
I'm extremely humbled, Mr. President, and we appreciate always your teachings, following your words always that the law is used to exploit the people, but our duty is to fight for justice because the poor need justice. And as we justice activists, human rights activists, we endeavor to stand and fight for that justice. So, Mr. President, we're extremely humbled, and you give us an assignment. You played your role. It's our time, the young people, the Wembos, the Shamir, the us, Yasin Sentumbe, people who have gone through your mentorship, and even what you have left behind, that we should now work on it and change this country and the countries around us. Set a precedent. Thank you so much, Mr. President. Once again, allow me to leave.
All right. Thank you so much, Ronald, for being with us, and also all the other online participants in this session. We are still having over 250 attendees on X as well as on Facebook. We have over 100. Ladies and gentlemen, lawyers, the general public, we don't want to take your presence, especially for this long period, lightly, because what we are doing is interrogating matters that have a lot of value, and we are at a juncture where we have to support each other, especially in the struggle, especially for the two topics that we had discussed today, the right to a fair hearing as well as the predicament of political prisoners. Ladies and gentlemen, we've come to the end of this session today. We'd like to thank in a very special way the president of the Ugandan Law Society, who has walked us through what we call a very invaluable talk, speech, lesson, and remarks all together, and he has given us a position. We have taken it in stride and would like to ask that we continue to follow the Ugandan Law Society and also be a part of these conversations where justice meets the law and the law is taken down to the people. We are grateful. We would like to thank you once again. We would like to thank the guest speakers who joined us, beginning from Advocate Philip Karugaba, beginning there, moving down to all the others, Jonathan Elotu, Ms. Shamim, the former guild president, Mr. Katushabe Ronald, who is still here with us, as well, of course.
Thank you.
You're welcome. And we would like to end the day and ask that we are excused till we meet again next Thursday for God and my country. Thank you and thank you.